Good evening, students. So, good evening to all my friends online and offline. Naveen is saying good evening to all of you. Okay. So, we have a question. Okay. Deepu Kumar is saying good evening, sir. I want to say thank you on behalf of my friend who attempted for UK PCS, United Kingdom Public Service Commission. 2022 last Sunday. He is not a student of our institute, but he read my polity class notes, and fortunately 4 questions were directly from there, like right to property, amendment related to National Commission for Backward Classes, anti-defection and State Legislative Council. Because of these 4 questions, he might qualify and cross. He called immediately after exam and wanted to say thank you and thank you once again. Okay. So party honi chahiye. Okay, so we will start. Okay. Good evening, sir. How are you? I'm good. So we'll start immediately. Okay. As you say that bandhs are unconstitutional. So Kaushal is asking. Okay. As you say that bandhs are unconstitutional, murder is also unconstitutional. But is it happening or not? So yes, and time and again the Supreme Court has fined political parties. And economic life of the country is impaired, so they have been fined and they have given money also. And before few months, the Legislative Assembly, there was some protest by some of the party workers. There was violence inside the Legislative Assembly, or some case was going on against some politicians, which was withdrawn by the state, because under CRPC, the state is empowered to withdraw cases. Criminal cases. So they withdrew that. The withdrawal was said to be unconstitutional and cases were continued by the Supreme Court. Some people wanted it to be declared under Article 19(1)(c), that is right to form an association, union and cooperative, and Article 19(1)(b), that is right to assemble peacefully without. Under this, they wanted the court to declare that bandh or right to strike is a fundamental right. Court said no, right to strike is not a fundamental right, not even a statutory right. And bandhs are unconstitutional because they are actually illegal. You stop somebody else from exercising his right. Okay. So what was the last thing we did on that day? Okay. There is a confusion regarding right to, is it a human right? It is a legal right. It is a legal right. No, right to property is a legal right. हाँ बोलिए एक सेकंड. As we know, the right to property is a global human right established by our Supreme Court and UNO. It is also a natural right. Which legal right? Correct. Okay, I'll give a conclusive answer. First of all, just to avoid any confusion, day before yesterday I was taking a batch of statutory bodies in, I think, some RB, I don't remember. So in I made them see Protection of Human Rights Act 1993, which established National Human Rights Commission. So National Human Rights Commission के act में Protection of Human Rights Act has a definition of human right. Which all human right cases can be taken by National Human Rights Commission? So cases, only those cases which are recognized by Constitution in India. So only those rights. See, human right, natural rights, these are very vague and broad terms. If there cannot be a remedy against them because there is no particular boundary which establishes a human right or a natural right. So if you do not recognize a right, rights are legally protected interest. So first you need to identify right, then only a protection shall be identified. So National Human Rights Commission can only take up those cases of rights which are established by the Constitution or ratified by India. Only those rights, any convention which has been signed and ratified by India, only those convention and the rights that are protected by the Constitution or any piece of legislation. So otherwise, human right and natural right is a very broad concept. Okay, so whichever rights are not acknowledged by a statutory provision will not be taken by Human Rights Commission, and also they can only take up cases of last 1 year. Any human right violation that has occurred in last 1 year, that is the maximum National Human Rights Commission can take. So this is why it was called toothless tiger. It was called toothless tiger because it can take up cases of last 1 year only. So the Human Rights Commission has a very, what you call, restrictive mandate when it comes to these issues. So there is no fixed definition of human right and natural rights. Undoubtedly, some scholars have worked that those rights which are attributed by virtue of being born in human family. So who will classify them? So there is no such classification even in Protection of Human Rights Act. Okay. Now anybody was asking a question. So right to property is a constitutional right and also a legal right. This is a fixed answer. Okay, and this question has been asked on 10th October 2021 in prelims. पूछिए, कोई पूछ रहा था कोई question? Okay, see, the term descent mentioned in Article 16, which is predominantly related to permanent resident or from where you are deriving your lineage. Okay, so there can be no discrimination on the basis of which lineage you are deriving as long as you are a citizen of India. And also it has the element of domicile in it. Okay, and these things matter only on reserved seats. गौर से सुनिए, अनरिजर्व सीट्स जो होती हैं किसी भी स्टेट पीएससी की, unreserved seat, that is general category seats, are open for everyone, but there can be the reserved seats of every, for example, you are a permanent resident of UP, you can apply for Bihar Public Service Commission, but you cannot apply for the reserved seats of Bihar Public Service Commission. For that, it is an affirmative action. For reservation, they have certain criteria that if you belong to a certain community, when did you come to that state? So states like Jharkhand, huge controversy is there because for reservation, they want to take it as back as they can. Getting my point? So if you are a resident of that state from 1932, in bit they wanted to make it 32. So if they will make it 32, more people will come or less people? It will be very, very. So there was huge hangama because there are people who have come after that. So finally they settled for somewhere in some 80s or whatever. So this is with respect to descent. On first, lineage ke basis pe koi discrimination nahi hogi. That your lineage, for example, you are an Anglo-Indian. Okay, so you have a lineage. And second, in matters of reserved seats, some cutoff date is taken for reservation. If you belong to a particular caste and also that you are a resident of that state, permanent resident. That is why Supreme Court asked the question that you have one citizenship and one domicile. Because what people do, it is very likely that you are from UP, you are staying in Delhi. You are from UP, you are staying in Rajasthan. You are from Bihar, you are staying in Delhi. This is very likely. So people get caste certificate from both the states. Okay, and then they apply for state PSC, or Delhi doesn't have a state PSC. They have Delhi Subordinate Selection Board. In that they recruit, and these people get promoted to Executive Magistrate and SDM. Otherwise, you have Delhi Andaman Nicobar Civil Services, that is DANIX. Okay, so they make domicile of two states. I personally know many cases. Many cases are going on in court because they, for example, somebody is from UP and the community is recognized as OBC in UP also as well as in Bihar. So they got reserved, what you call reservation in domicile in UP also as well as Bihar, has got selected in subordinate judicial services. So somebody complained or something happened, so a case is going on. So for reservation, every state has taken a particular date. इससे पहले के आप हैं तो उस state में reservation benefits नहीं मिलेंगे. And for SC, Article 341 of the Constitution, SC is only determined at central level. Okay, for reserve category states, state can recognize. They have their, in many states, like in Bihar, you don't even have ST reservation, very little percentage. Why? After Jharkhand was bifurcated, ST population went to Jharkhand. One Lok Sabha seat was reserved for ST community in Bihar. That Lok Sabha seat also is no more. So reservation is an affirmative action. The state can give only to the communities of their particular state. Okay, but when it comes to unreserved seats, there you have an equal right. Only thing which the state will do is, they will come up with a qualifying exam. So if you want to apply for Tamil Nadu Public Service Commission, welcome, you go and apply for unreserved seats, but you have to qualify a paper of Tamil. And in some states like UP, they have made it a merit-based exam. For example, our brothers and sisters from southern part of the country, somebody from Karnataka want to apply for UPPSC. So Hindi is counted in merit. If it is counted in merit, then what will happen? Somehow they can score qualifying marks, but that would be a big gap. So this is the basis, okay? So unreserved seats, you just need to understand this much, that what is the basis of discrimination. What was the last article we were doing? 20? We completed Article 20. Major amendments have happened. Major amendments have happened in a criminal procedure code related to the biometrics that can be collected at the time of arrest, after arrest, when you are in custody, and how National Crime Records Bureau and how they will be having access to data, everything. This definitely will be covered under the, I am personally waiting. I will be, after the bill has been passed by both the houses, I will go through the bill personally. I will prepare my own notes and then we will discuss in the current affairs. Okay. So Article 20 of the Constitution establishes 3 things. 1, no ex post facto law. So no criminal law can be retrospectively applied. Second, no double jeopardy. Double jeopardy has an exception. What is that exception? What is that exception? Huh? Administrative action is not counted in double jeopardy. Okay. And the third thing is no self-incrimination. There is a famous case I told you, na? Or there are certain other things also in an Indian Evidence Act to what extent evidences can be admissible. Okay. So you cannot be forced to be a witness against yourself. Now the next right that is there is Article 21 of the Constitution. What is Article 21? First of all, it says no person. So the moment it says no person, it means citizens as well as non-citizens. First thing. Second thing, Article 359 of the Constitution says that Article 20 and Article 21 cannot be suspended even during emergency. So Article 20 and Article 20, this can be a pure prelims question, that Article 20 and Article 21 cannot be suspended even during emergency. So this is the level of sanctity of Article 21 of the Constitution. It says no person shall be deprived of life or personal liberty except procedure established by law. So you cannot be deprived of your life. यानी आपको हैंग नहीं किया जा सकता है. Or personal liberty, you cannot be curtailed. Your liberty cannot be restricted except procedure established by law. So if the law says that you have committed an offense of murder, which is defined under IPC 299 and punishment is prescribed in 302. So no person can be deprived of his life except procedure established by law. So if you have committed an offense, which is an offense in the law, your life can be taken away. No person can be deprived of life. Life आपसे छीनी नहीं जा सकती है except procedure established by law until you have broken a law. So if you have broken a law and that prescribes that your life can be taken away, you can be hanged. No person can be deprived of life or personal liberty. You cannot be confined until you have broken a law. Now we will see the wider dimension of Article 21 of the Constitution. This is just a basic thing. So is it applicable to citizens as well as non-citizens alike? So every such right which establishes the, what you call the democratic, liberal democratic character of Indian state, most of them have been available, especially Article 14, available to both citizens and non-citizens. Article 21 available to both citizens and non-citizens. Not only citizens but also on non-citizens. Okay? Sir, I am missing you. अब सुनिए, ओ ये हो गया. I have the same setup at my home also, so I know this. I'm familiar with this. Although I never switch on after January. Sometime my friends visit to the Amazon. Otherwise, that too very, very rare. Actually, YouTube provides you the liberty. The liberty to see what is human quest. Why are we not fed up with smartphone, but we are fed up with humans? Because humans are different mind. They cannot react like you want all the time. If you want to be happy, they cannot be happy because they are different individuals. But YouTube offers you that space. If you want to watch sports, it is there. So it offers you to, it treats you the way you want it to be treated, and actually you become a slave. By giving you too much liberty, you are the slave of the liberty. Freedom के आप slave हो गए. जैसे किसी बच्चे को आजादी की बहुत आदत पड़ जाती है. There is a phrase in English: spare the rod, spoil the child. Spare the rod, spoil the child. When our parents took us to school, they sent to my father told to the teacher that skin belongs to you, bone belongs to me. Okay, so we have Article 21 of the Constitution. He says 1985 they have taken Jharkhand. Okay, so we have Article 21 of the Constitution. Before, from exam perspective, 4 terms are there which have been asked in innumerable exams. One is equality before law. Second is equal protection of laws. Third is procedure established by law. And fourth is due process of law. ये 4 टर्म जो हैं, they have been asked in almost all the exams on earth. Okay, in India, any exam that is conducted, they have asked question from these 4 terms, from where they have been lifted, what is the concept coming out of these terms, have been asked consistently on all the exams. Okay, and one term, that is equality before law. This is, what is the mother of equality before law? There are 3 children. Rule of law has 3 children. Equality before law, predominance of legal spirit, rights and supremacy. Okay, so you have equality before law के father हैं rule of law, and rule of law has been declared by Supreme Court as basic structure of the Constitution. Okay, so now you have these 4 concepts. We are dealing with Article 21. These 2 concepts are not related to Article 21, but class should be from exam perspective. You should be very easy in the examination hall. It should be halwa. So for that, these 4 terms must be remembered like anything. So equality before law is a positive connotation or a negative connotation? It is a negative connotation, like nobody can be treated differently. Absence of any special privileges. Everybody is equal in the eyes of law. So this is a negative concept, and this has been taken from United Kingdom. So this is taken from United Kingdom, and it is as a negative connotation. Then you have equal protection of laws, which says it is a positive connotation, and the state shall be treating, likes should be treated alike and unlike should not be. यानी दो वो लोग जो एक जैसी समान स्थिति में है, उनके साथ एक सा ट्रीटमेंट होगा, और जो एक जैसी स्थिति में नहीं है, उनके साथ एक सा ट्रीटमेंट नहीं होगा. Like those people who belong to economically weaker section, they will be treated in one category, and those who do not belong to economically weaker section, they will be treated in different category. So like should be treated alike, and unlike should not be. Those who are like each other, they must be treated alike, and those who are not like each other, they must not be treated alike. And protective discrimination is a facet of equality. If 2 children in the class are not feeling well, and Vision IS is providing substantive meal and conveyance to them, so it is not that they are given something extra. They are only being helped to regain the health. So protective discrimination is a facet of equality, and this is a positive discrimination, and this is an American concept. That is equal protection of law. So this is a positive concept, and this is an American concept. Now procedure established by law. Procedure established by law को लेकर, although in Lakshmikant all the books you will see it is written that it is from Japan. ठीक है, हर जगह लिखा है. But some scholars have a different idea. First of all, Japan and India have commonalities. We both are net importers of energy. We both are traditional societies. We both are parliamentary democracies. We both have procedure established by law. So with Japan, India has commonalities. Okay, so undoubtedly you see procedure established by law. Simple सी बात है. In the draft constitution we added due process of law only. You have heard about B.N. Rao. All of you must have heard about him. He was the advisor to Constituent Assembly. When on 25th November 1949 entire constitution was prepared, you read the debates of Constituent Assembly. Dr. Ambedkar stood on the dais for the last time. First he said thank you to B.N. Rao. He said, I want to thank the advisor to Constituent Assembly, Mr. B.N. Rao, without whose effort this constitution would not have been a possibility. So Dr. Ambedkar thanked him. Why I am bringing Mr. B.N. Rao? He was the advisor to Constituent Assembly. State PSC का perfect question है. Okay, who was the advisor to Constituent Assembly? So it was Mr. B.N. Rao. So B.N. Rao went to United States of America. In the draft constitution, we have added in Article 21 due process of law. So he went to United States of America, met the judge of US Supreme Court and said that our constitution is being drafted. We want to add either due process of law or procedure established by law. In US constitution also, the term judicial review is not mentioned. In US constitution also, the term judicial review nahi mentioned hai. I have read at least 50 times. Okay, so they have not also clearly mentioned judicial review. But if you go deeper, due process of law that is mentioned there, due process of law actually gives a wider power to judiciary. गौर से सुनिए. Whenever a law is passed by legislature, जब भी legislature कोई law pass करता है, या or there is a executive order that is issued by the ministry, so it can be judicially reviewed. Okay, so in due process of law there is wider power to the judiciary. Judiciary will first see whether the law has, for example, somebody is arrested, okay, and somebody is challenging his arrest. So first thing judiciary will see whether the person has been arrested under a law. So yes, he has been arrested under a law. Whether the law has been passed by appropriate authority. Panchayat ne to law nahi pass kiya hai. So the law has been passed by an appropriate authority. Third, whether all the procedure were followed while passing the law. So yes, both the houses passed the law, there was majority and president gave approval to the bill or the governor, as the case may be. So in procedure established by law, court bas itna hi karega. Now this question has been asked n number of times, I'll come to that question. Now listen to me very, very carefully. In procedure established by law, you are arrested and somebody is challenging your arrest, or you yourself are challenging your arrest. Court ka kaam teen cheez dekhna hai. First, whether the person is arrested under a law. So yes, this person is arrested under the law. Second, whether the law has been passed by a competent authority. Yes, the law has been passed by parliament. Third, whether all the procedure was followed while making the law. Yes, all the procedure was followed. Now the court will not go into reasonability, justification or arbitrariness of the law. Whatever just, fair, just and reasonable law है कि नहीं, ये कोर्ट का काम नहीं है. समझ रहे हैं आप लोग? Everybody is understanding. कोर्ट ये नहीं देखेगा लॉ फेयर है कि नहीं, लॉ जस्ट है कि नहीं, लॉ रीजनेबल है कि नहीं. अभी पूरी बात सुनिएगा तब समझ में आएगा. So court will not go into the rationality of the law. It can only check whether there is a law and you have been arrested under the law. So one statement has been asked. So do you think in procedure established by law the power of court is more or less? It is very less. So this statement has been asked 2 lakh times, that procedure established by law saves you from executive action but does not save you from legislative action. इसका मतलब समझ रहे हैं? If the DM passes an order कि anybody who wears white shirt will be hanged. So this is a very, very irrational order and there is no law that justifies this order. So that order can be declared unconstitutional by judiciary. So judiciary can save you from executive action, but it cannot save you from legislative action. However unreasonable, arbitrary or unfair law it is, judiciary का काम नहीं है देखना कि law सही है या गलत है, fair है या just है, नहीं है, ये नहीं. Judiciary would just see whether there is a law, the law has been passed by competent authority, and the law has, all the procedure has been followed while making the law. So procedure established by law gives a narrow connotation to judicial review or wide? Narrow. ड्यू प्रोसेस ऑफ लॉ में यूएस सुप्रीम कोर्ट के पास एक हथियार है और हमारे सुप्रीम कोर्ट के पास एक हथियार है. यूएस सुप्रीम कोर्ट के पास ड्यू प्रोसेस, हमेशा डिबेट चलती है दुनिया के स्कॉलर्स में, विच सुप्रीम कोर्ट इज मोर पावरफुल, यूएस सुप्रीम कोर्ट और इंडियन. All the scholars had a belief that US Supreme Court is the most powerful Supreme Court. इतनी powerful है कि it is called the third law making chamber. US Supreme Court को third law making chamber कहते हैं. Why? Because the term due process of law has been used in the constitution. In due process of law, judiciary ये भी check करेगी whether the law is fair, just and reasonable. So it has wider powers of जुडिशियल रिव्यू, यानी किसी भी लॉ को किसी भी तरीके से इंटरप्रेट करके एनी मैनर दे कैन कॉन्स्ट्रू अ पीस ऑफ लेजिस्लेशन. सो इट गिव्स वाइडेस्ट ऑफ एम्पलीट्यूड व्हाइल एक्सरसाइजिंग द पावर्स ऑफ जुडिशियल रिव्यू. इन प्रोसीजर एस्टैब्लिश्ड बाय लॉ द पावर्स ऑफ द कोर्ट आर कॉन्स्ट्रिक्टेड. अब क्या है? सो इन ड्राफ्ट कॉन्स्टिट्यूशन वी एडेड ड्यू प्रोसेस ऑफ लॉ. ड्राफ्ट कॉन्स्टिट्यूशन मतलब ओरिजिनल कॉन्स्टिट्यूशन से पहले. BN Rao took a flight, went to United States, and there he consulted the judge of US Supreme Court. The judge of US Supreme Court said judiciary is not directly accountable. They are not elected people, so they are not accountable to parliament. So in a democracy it is better to go for procedure established by law. Otherwise, see, we did not have good experience after due process of law. So he returned back, and in the constitution that was proposed before the Constituent Assembly, we changed the term due process of law to procedure established by law. So this question has been asked n number of times, that in your test series also you'll find some of the other day, that procedure established by law saves you from executive action but does not save you from legislative action, while due process of law saves you from both arbitrary executive action and legislative action, giving amplitude widest of power to the court to interpret a piece of legislation. इतना wide power कि US की जो parliament है, दो विंग है. देयर आर, यूएस कांग्रेस हैज टू विंग, हाउस ऑफ रिप्रेजेंटेटिव्स एंड सेनेट, और तीसरा कहा जाता है सुप्रीम कोर्ट. द थर्ड लॉ मेकिंग चेंबर को इनफॉर्मली यू कॉल इट सुप्रीम कोर्ट. इट हैज सच वाइड पावर्स. अब इंडिया आते हैं. सो इनिशियली प्रोसीजर एस्टैब्लिश्ड बाय लॉ वाज देयर, कोर्ट वाज हैविंग अ वेरी रेस्ट्रिक्टिव, बट इन मेनका गांधी वर्सेस यूनियन ऑफ इंडिया, फॉरएवर इट चेंज्ड. The Supreme Court in one of the, not in obiter dicta, but in the ratio decidendi, that is the judgment part, Supreme Court in one of the paragraph ruled that although the term due process of law has not been mentioned in Indian Constitution, although the term due process of law has not been mentioned in Indian Constitution, but while exercising a judicial review, we will also see the law through the prism of fairness, justice and reasonability. हम भी देखेंगे लॉ को फेयर है कि नहीं, जस्ट है कि नहीं, और reasonable है कि नहीं. So due process of law, this question has been asked whether the Constitution of India has due process of law or not. कोई confusion नहीं है, you will say no. But the elements of due process of law, that is fairness, justness and reasonability, has been brought into Indian constitutional jurisprudence by Maneka Gandhi versus Union of India. And Supreme, now you will say how? कोई जवाब नहीं है. I was watching one of the interviews of Mr. Arun Jaitley when he was law minister. And 99th Constitutional Amendment Act was declared unconstitutional on 16th October 2015 in Supreme Court Advocate on Record Association versus Union of India case. पूरे 99th Constitutional Amendment को Supreme Court ने unconstitutional कहा. So Mr. Jaitley was the law minister. He made a statement that from where the term basic structure came. Of course he was right, because the term basic structure is not mentioned in the Constitution. The term, what do you mean by the term consultation? दुनिया की किसी भी डिक्शनरी में what is the meaning of term consultation? Exchange of opinion. It may be or may not be accepted. But the Supreme Court in interpretation of Article 124 said that the term consultation in Article 124 means binding. Getting my point? So they have interpreted the term, so without a shadow of doubt, judiciary is the final interpreter of the Constitution. अब जुडिशरी के मुंह से सुनिए क्या कह रहे हैं. I was reading a judgment, People's Union for Civil Liberty. सुप्रीम कोर्ट ने एक पैराग्राफ में कहा, while exercising judicial review, we also perform marginal degree of legislative exercise. कोर्ट ने यह कह दिया, while exercising judicial review, जब हम judicial review कर रहे होते हैं, थोड़ा सा law making हम भी कर देते हैं. We also exercise marginal degree of legislative exercise. एक केस में सुप्रीम कोर्ट ने कहा, I think this was in बंधुआ मुक्ति मोर्चा केस, Constitution is supreme, but we will say what is Constitution. Constitution is supreme, but we will say what is Constitution because we are the final interpreter of the Constitution. So every scholar would write on a piece of paper that all three organs are equal. But दिल में उसको मालूम है कि judiciary has an edge because it is the final interpreter of the Constitution. So due process of law gives widest of amplitude. US में Supreme Court is एक vacancy खाली होती है ना. It is like in India becoming chief minister of a state. If one vacancy is there in US Supreme Court, 9 judges हैं, एक vacancy 7 या 9 है, एक vacancy खाली होती है, हंगामा मच जाता है. Why? Because there is no retirement age. One wrong appointment in US Federal Supreme Court, it is done. Once you are appointed, there is no retirement age, you remain judge till you are alive. And there are less number of judges. So, uske liye, and the president nominates the judge and it is approved by the Senate. So, judge jo hai US Supreme Court mein, Federal Supreme Court ka judge is a very big thing. So, I will give you two examples. And then you will understand the enormity of appointing a judge, and then we will come to due process of law. Barack Obama, on 20th January 2017, Donald Jr. Trump became the 45th president of USA. Mr. Obama in 2016 nominated a judge to US Supreme Court. But Democrats were not having majority in Senate, so did not approve the appointment made by the president. So he wrote a Facebook post that they said that it is morally incorrect for an outgoing president to nominate it is morally, ethically incorrect for an outgoing president in last year of his presidency to nominate a Supreme Court judge. So he wrote a Facebook post that where it is written in the Constitution that I cannot nominate a judge in my last year of presidency. So this is that. Now, Mr. Trump, when Mr. Trump was also appointed one of the judges, it is expected at times that when you appoint a judge, he has an ideological bent. So a judge he appointed, it was expected that in cases against him, he will be a bit lenient, but that didn't happen. Okay, so appointment of a judge in UN Supreme Court is of extreme significance because he is there for life and there is a due process of law. So any law can be interpreted in the manner they want, and Supreme Court of USA is very powerful. Like we have one Brahmastra, that is Article 136 of the Constitution. जैसे special leave petition हमारे पास है, we will see that. So due process of law means the judiciary shall be checking the law through the prism of reasonability, justness and fairness also, and they have widest of amplitude while exercising judicial review. और procedure established by law में judiciary का काम है सिर्फ ये देखना. They have the task to see whether there is a law, the law has been passed by an appropriate authority following all the procedures. Second, now अभी Article 21 शुरू हुआ है. Now the point is, now right to life. Okay. Why do you think that right to life is very important? Cardinal? Because it is the basic of all rights. Okay. So it says, so now you see these four have been consistently asked. Equality before law, एक negative concept है और British concept है. Equal protection of laws एक positive concept है और American concept है. Procedure established by law is said to have been borrowed from Japan, but some scholars say that procedure established by law also has British connotations. It was also a part of equality before law. So if you get any such thing, it traces its origin in the idea of equality before law. Okay? And due process of law is again an American concept. So equal protection of laws is an American concept, and due process of law is also an American concept. Which gives widest of amplitude of judicial review? Due process of law. Now in Menka Gandhi case, Menka Gandhi versus Union of India, there was a case related to passport. I told you Article 19(1)(g), right to practice my profession. If I am a musician, I have to perform in London. So my profession gets hampered if I am not allowed to travel abroad. So right to practice my profession also includes right to travel abroad. So right to travel abroad is under Article 21 of the Constitution. पिछले 3 सालों में 2 बार क्वेश्चन आया है. In last 3 years they have asked 2 times question. एक बार पूछा, हदिया केस हुआ. You know about the Hadiya case? So there was a couple from Kerala. Okay. So the girl converted and they both married. So once, for example, you must have heard about Special Marriage Act. Okay. Special Marriage Act. So what is Special Marriage Act? बताइए, सुना है कभी? It allows interfaith marriage. यही सुने है ना? यही मैं नहीं चाहता था बोले. यही सबसे बड़ा मिसकंसेप्शन है. जैसे और भी कई मिसकंसेप्शंस हैं कि आईपीसी 377 को डीक्रिमिनलाइज कर दिया गया है. एक बहुत ही कॉमन मिसकंसेप्शन है कि आईपीसी 377 हैज बीन डीक्रिम. आईपीसी 377 स्टिल इज अ perfect section in IPC. It is only consensual sex between adults in private of the same gender has been the interspecies sex or any other form of sex that is unnatural still is a criminal ऑफेंस, ओनली दैट पार्ट. अब एक धारणा है कि स्पेशल मैरिज एक्ट इज फॉर इंटरफेथ कपल. नहीं, एनीबडी हु विशेस टू गिव अप हिज पर्सनल लॉज, any couple who wishes to give up his personal laws and marry under the special marriage act, now his, for example, in Muslims, property is distributed as per Muslim. So many law students sitting in the class, one of the toughest paper in law is Muslim law, personal law. So Muslim personal law, क्योंकि उसमें फॉर्मूला होता है. कुछ भी आप ज्ञान नहीं लिख सकते. प्योर मैथमेटिक्स फॉर्मूला है कि ग्रैंडफादर से ग्रैंड डॉटर, और आपको परसेंटेज लिखना है. That is the, honestly speaking, that is the only paper in 30 papers where I found it a bit difficult. Because पूरा mathematics है. Getting my point? उसमें एक बेटे से दो बेटा, फिर एक की शादी हो गई, फिर दूसरे की नहीं हुई, उसके नीचे. So percentage wise you have to calculate until you know it very precisely. Now Muslims की property distribute होती है उनके हिसाब से. Muslim Shariat Application Act 1937, and you have Muslim personal laws are applicable in inheritance of Muslims. Hindus have a beautiful what you call what secular law, where both daughter and son, they both get equal property. Okay, so the point is, anybody who wishes to give up his personal law can marry under the special marriage act. Now if Hindu and Muslim are marrying, Muslim and Sikh are marrying, so actually kiska law applicable hoga inheritance mein? So they marry under special marriage act, so they both are giving their personal laws. So can two Hindus marry under special marriage act, or can two Muslims marry under special marriage act? Yes, without a shadow of doubt. Only thing is they are declaring that we are giving up our personal laws. समझ है? तो ये एक परसेप्शन है कि भाग के कपल शादी करते हैं स्पेशल. इट्स अ फैक्ट. It's a very honest fact. They marry under, any two couple of the same religion can also marry under special marriage act if they want to give up their personal laws. So there is a special marriage act. So we started the discussion from due process of law में. So हाँ, अब याद आया. तो the point is कि there is a famous case. क्यों UPSC ने question पूछा? A girl converted to Islam, okay, and once she converted to Islam, now she comes under the personal laws of Islam. Okay. See, in class we will say Hinduism, Islam, Sikh. हम लोग सिर्फ मार्क्स उठाने आए हैं. हमारी आइडियोलॉजी सिर्फ यूपीएससी है. जो भी बात से आपको मार्क्स मिलेगा विल डिस्कस. कोई हमारा we are actually opportunist. Okay. If they will say कि what do you think about this, we'll say yes sir, of course. So our only purpose is, we are not human beings, we are robots. What will fetch us marks, we will write. We are least concerned about we don't have any ideology. Okay, we don't have any, we are fluid. We can adjust everywhere. Okay, so the point is कि a girl, just for your concept, don't write these things so that you understand why UPSC asked this question in 2020. So right to life पे जो question आया 2 साल में, वो discuss कर रहा हूँ article 21 में. So a girl married after converting to Islam, she married to a guy. Okay, so she married to a guy. Now she is coming under which law? Personal laws. Okay, so the marriage was challenged by her father in Kerala High Court. That since the conversion was illegal, so her marriage is also illegal, because two people of different religion cannot marry under the personal law of one religion. So they should have married under special marriage act. So this Kerala High Court declared that marriage as unconstitutional, illegal and void. So the couple approached Supreme Court. Okay, and the Supreme Court asked the girl to stay with the parents for 6 weeks or 6 months. After 6 months, Supreme Court called the girl, one of the most famous cases, and in the courtroom, they asked her opinion. Okay, so in that case, Supreme Court, finally she said that I want to stay with that guy, and they both went. Okay, so this was, the Supreme Court in that case ruled that right to marry someone is also a right under Article 21 of the Constitution. UPSC ने दूसरे साल क्वेश्चन दाग दिया कि right to marry someone is under which of the article of the Constitution, that is Article 21. एक क्वेश्चन यूपीएससी ने पूछा. दूसरा क्वेश्चन यूपीएससी ने केएस पुट्टू स्वामी वर्सेस यूनियन ऑफ इंडिया, दैट इज पॉपुलरली नोन एज आधार और राइट टू प्राइवेसी केस. उस केस में सुप्रीम कोर्ट ने कहा था राइट टू प्राइवेसी इज आल्सो एन इंपॉर्टेंट पार्ट ऑफ राइट टू लाइफ. फिर यूपीएससी ने पूछा, इससे तो एकदम इजी, दिस वाज लाइक लॉलीपॉप ही क्वेश्चन है ना ये, राइट टू मैरी समवन इज अंडर विच आर्टिकल. सो 2 क्वेश्चंस हैव बीन आस्क्ड फ्रॉम आर्टिकल 21 इन सिविल सर्विसेज एग्जामिनेशन 2019 and 2020. that right to marry someone and right to privacy is under which article of the constitution? It is article 21, that is right to life. और दोनों क्वेश्चन क्यों पूछा, इसके पीछे भी immediate judgment था सुप्रीम कोर्ट का. That is why, so we can expect questions on that. So now article 21 of the constitution has been expanded by Supreme Court like anything. Right to reputation, Kiran Bedi case. Right to clean, access to clean environment, MC Mehta case. और MC Mehta का एक केस नहीं है. I have read at least 5 cases. MC Mehta, Kanpur Tannery case, MC Mehta, Ganga case, MC Mehta versus Kamal Nath. So many cases have been, he was a spirited environmentalist. So you have a right to clean environment, right to reputation, right to speedy trial, Hussain Ara Khatun versus State of Bihar. So then you have right to what you call right against sexual harassment at workplace, Vishaka versus State of Rajasthan. So getting my point, so right to life has been given maximum expansion by the Supreme Court in various judgments delivered by the Honorable Supreme Court, and every judgment delivered by Supreme Court has sanctity of a law and is valid, is binding on all courts in India. Under Article 141. Article 141 of the Constitution says that every judgment of Supreme Court shall be binding on all courts in India. So it has a, by Article 129 establishes Supreme Court as a court of record. So its judgments, its everything is admissible in any court in India. So Supreme Court has also ruled. Next important thing related to Article 21 कहा जाता है, this can be a prelims conceptual statement. What can be the conceptual statement? If you delete all the articles of the Constitution, only one article is empowered enough to expand all other articles. That is Article 21. By a liberal interpretation of Article 21, it can give birth to all other articles. You see the magnitude. There, I will tell you, ऐसे तो cases we can discuss hundreds such cases. One interesting case I'll tell you. How the Supreme Court expanded the scope of Article 21. There was a lady who came from Bangladesh. And she was staying at Rail Yatri Niwas, Kolkata, Howrah railway station. And there she was subjected to rape. So actually what happened, she was raped and there was a lady lawyer, Chandrima Das. She filed a PIL that one, Howrah railway station should be cleared of what you call antisocial element, and second, 10 lakh compensation should be given by the railways to that Bangladeshi national. So this was an interesting case related to the expansion of the principle of locus standi. कि क्या किसी PIL के जरिए किसी एक व्यक्ति को 10 लाख रुपया दिलवाया जा सकता? Can a personal interest be pursued through a public interest litigation? And the railway chairman of the railway board challenged the verdict in the Supreme Court. And the landmark judgment given by Supreme Court where it ordered 10 lakh compensation through Bangladesh High Commission to that particular lady because she was staying at the railway premises. Although the railway staffs were not involved, but it was the duty of railway to provide her security and 10 lakh rupees compensation. And PIL was also treated to give some personal benefit to a particular individual. Okay, so article, and the Supreme Court ruled sexual harassment is violation of Article 21. और विशाखा वर्सेस स्टेट ऑफ राजस्थान, ये तो बचपन से सुनते आए, सबसे फेमस केस है विशाखा वर्सेस स्टेट ऑफ राजस्थान. ओके, सो इन विशाखा इंडिया ने एक कन्वेंशन साइन किया. कन्वेंशन का नाम है यूएन कन्वेंशन ऑन एलिमिनेशन ऑफ ऑल फॉर्म्स ऑफ डिस्क्रिमिनेशन अगेंस्ट विमेन. UN Convention on Elimination of All Forms of Discrimination Against Women. So Vishaka versus State of Rajasthan is one of the most landmark cases of Supreme Court for sexual harassment of women at workplace. So Vishaka was a lady who was like Asha, and she was working with Rajasthan government, and things happened. So finally the case went to Supreme Court. There was no law in India. इंडिया में ऐसा कोई भी लॉ नहीं था जो सेक्सुअल हैरेसमेंट ऑफ विमेन एट वर्क प्लेस. इंडिया में ऐसा कोई भी लॉ नहीं था विच वॉज डीलिंग विद सेक्सुअल हैरेसमेंट ऑफ विमेन एट वर्क प्लेस. सुप्रीम कोर्ट गेव अ लैंडमार्क रूलिंग अंडर आर्टिकल 21 ऑफ द कॉन्स्टिट्यूशन. सुप्रीम कोर्ट ने दो बात कही. कहा फर्स्ट, इफ देर इज नो म्यूनिसिपल लॉ, मतलब डोमेस्टिक लॉ अगर कोई नहीं है, and India has signed and ratified an international treaty, international law will fill the gap of municipal law. अगर कोई म्यूनिसिपल या डोमेस्टिक लॉ नहीं है and India has signed as well as Parliament has ratified, since India has signed UN Convention on Elimination of All Forms of Discrimination Against Women, an international law will fill the void of Domestic law. First thing Supreme Court said. Second thing said, right, sexual harassment of women in any form and especially at workplace is afferent to violation of right to life. So this can be the third question which UPSC will be asking next year, that sexual harassment, if they can ask, of women at workplace is a violation of which of the rights? So again it is Article 21 of the Constitution as ruled by Supreme Court in Vishaka versus State of Rajasthan. So Article 21 is, अब Article 21 का एक और example देते हैं. Okay, you must have heard about a very beautiful satire on democracy, that is Andher Nagri Chaupat Raja. It is a beautiful play that satires on democracy. So in that play what happens? There is a saint and there are two chelas, the disciples. They are walking across a city. They see that in this city, Andher Nagri Chaupat Raja, Takesir Bhaji, Takesir Khaja. So there's nothing, absolutely nothing to laugh. So a Takesir Bhaji, Takesir Khaja, matlab the cost of a sweet dish is equal to that of a sour dish. So the person who is selling the sweet dish is forced to sell the sweet dish and the salty dish at the same price. Kyunki the king has ordered. So it is not rule of law, it is not lex is rex, but it is rex is lex. It is the king which is the law, and law is not equal. So the saint, the two disciples become very excited. They say कि I will stay here only because यहाँ तो उतने ही पैसे में मीठी चीज भी मिलती है और नमकीन भी. Saint says no, this is against the principle of justice. ये इंसाफ के खिलाफ है, यहाँ मत रुको. The saint walks by and the two disciples stay there in the city. This is a satire on democracy. This play was very popular. Okay. So then what happens? The two disciples stay and they start eating too much. Okay, because they were getting वही उसी पैसे में salty dish भी, उसी sweet dish भी. After that what happened? A person was to be hanged. Or the rope that was made, actually the size of rope was not fitting to the person who was to be hanged. So the king says that this land has no equality before law. जो भी इस size का मिले उसको टांग दो. So one of the person, they were enjoying, relishing and enjoying on the streets. One of them were caught by the policeman and उसका गला एकदम फंदे के भर, क्योंकि वहां rule of law तो है नहीं. Equality before law, rights, predominance of legal spirit, there is no supremacy of constitution. Whatever Rex says is lex. King is law. उसको उठा के लाता है, फांसी चढ़ाने लगता है. He is about to be hanged. He remembers the Guru and suddenly the Guruji appears and says ki I told you, you should not stay here. There is no justice in this city. And the Guru says to the king, please hang me. I just had a dream that whoever will be hanged now will be sent to heaven. So the king says that I want to be hanged. And the king was hanged and the play ends. Okay, so this is a satire on democracy, that there should be rule of law and law should be equal for everyone. So from this entire perspective, Article 21 is such important that it can give birth to other articles also, and it can establish any of the rights. Okay, so Article 21 पे बार-बार question आता है, and you must understand that although if there is a statement that the due process of law has been incorporated in Indian Constitution, you will say true or false. False. पर mains में you will write the principles of due process of law, that is fairness, justness and reasonability, have been incorporated into Indian constitutional jurisprudence by the Supreme Court in Maneka Gandhi versus Union of India. अब तो कहानी बहुत आगे. Supreme Court sees the law, but of course there is one thing. Any law that is challenged in Supreme Court, कोई भी law is constitutionally valid till the time it is declared as unconstitutional. कितना भी ब्लेटेंटली अनकॉन्स्टिट्यूशनल लॉ हो, जब तक उसको अनकॉन्स्टिट्यूशनल घोषित नहीं किया गया है तब तक वो कॉन्स्टिट्यूशनली वैलिड है, एंड द ओनस लाइज ऑन द पर्सन हु इज चैलेंजिंग द वैलिडिटी टू प्रूव दैट वेदर द लॉ इज कॉन्स्टिट्यूशनल और unconstitutional. It is not, the onus does not lie on the state to justify. Onus lies on the person. He has to convincingly prove to before the court that the law is not fair, just and reasonable. So please write right to life. Right to life. Okay, right to life. Article 21 of the Constitution. Article 21 of the Constitution provides for the establishment of a liberal democratic state, provides for the establishment of a liberal democratic state, provides for the establishment of a liberal democratic state, wherein no person shall be deprived of, wherein no person shall be deprived of life or personal liberty, wherein no person shall be deprived of life or personal liberty except according to procedure established by law, except according to procedure established by law, except according to procedure established by law. अभी खत्म नहीं हुआ आर्टिकल 21, अभी 1-2 घंटे और चलेगा, क्योंकि इसमें एक्टिव यूथेनेसिया है, पैसिव यूथेनेसिया है, राइट टू प्रिवेसी है, राइट टू डाई है. वी आर जस्ट डीलिंग विद एट द ऑनसेट. ओके, सो क्या लिखा आपने? प्रोसीजर एस्टैब्लिश बाय लॉ, फुल स्टॉप. आगे लिखिए. The four terms in popular parlance, अभी ये चारों मैं लिखवा देता हूं. 4 terms in popular parlance, मतलब कोलोकियल, मतलब बोलचाल की भाषा में, are as follows. ये भी लिख लीजिए. as follows. 4 terms in popular parlance, मतलब बोलचाल की भाषा में, are as follows. FOLLOWS. ओके, as follows. अरे भाई, PARLANCE. ओके, मतलब एक इक्वालिटी बिफोर लॉ, प्लीज राइट. ये चारों लिख लीजिए यहां पे. ये क्वेश्चन कई बार आ चुका है और चारों एक जगह होगा, रिवाइज करने में आसानी होगी. यू विल फाइंड इट वेरी इजी एंड दे विल आस्क अ क्वेश्चन फ्रॉम दिस. इक्वालिटी बिफोर लॉ, a negative term, a negative connotation, comma, British concept. Negative connotation, British concept. Then you write equal protection of laws. चारों को मिला के क्वेश्चन पूछते हैं. Equal protection of laws. American concept, positive concept. American concept, positive concept. American concept and positive concept. Okay. Next, तीसरा क्या है बताइए? Due process of law. Due process of law. American concept, comma, gives widest amplitude to judicial review, gives widest amplitude to judicial review, gives widest amplitude to judicial review, and to the extent that, gives widest amplitude to judicial review, and to the extent that American Supreme Court is informally termed as, and to the extent that American Supreme Court is informally termed as third lawmaking chamber. Third lawmaking chamber. Also write, the Constituent Assembly initially wanted to incorporate third lawmaking chamber, full stop. The Constituent Assembly initially wanted to incorporate the Constituent Assembly initially wanted to incorporate due process of law. Incorporate due process of law. but after wide consultation, initially wanted to incorporate due process of law, but after wide consultation, we settled for, after wide consultation, we settled for procedure established by law. We settled for procedure established by law. ठीक है? Full stop. ये चारों कंफ्यूजिंग है, एक से लगते हैं भाई भाई, पर अलग अलग हैं ये. ओके, दे लुक लाइक, बट क्वेश्चन यहीं से आता है, हर एक आध क्वेश्चन. ओके, एंड व्हाट इज द लास्ट? दैट इज प्रोसीजर एस्टैब्लिश्ड बाय लॉ. Procedure established by law. Please write. Procedure established by law. It put a dash, semicolon, and write. It has been borrowed from Japanese constitution. It has been borrowed from Japanese constitution. It has been borrowed from Japanese constitution. Bracket में लिखिए. Although some scholars trace British origin. Although some scholars trace British origin. Okay? Although some scholars trace British origin. ठीक है? तो full stop. Now we'll get back to article 21. ये चार मैंने ऐसे ही लिखवा दिया. Please write. Article 21. Article 21 is available to citizens and non-citizens alike. Article 21 is available to citizens and non-citizens alike. Full stop. Then you next point you write, principle of natural justice. Principle of natural justice is also an important element. Principle of natural justice is also an important element, though it is not explicitly mentioned. Though it is not explicitly mentioned. ठीक है? Now please write, dear students. जस्टिस भगवती का एक स्टेटमेंट दे रहा हूं, मेंस में कहीं जहां मौका मिले बस. सो जस्टिस भगवती highlighted the importance of right to life. Justice Bhagwati highlighted the importance of right to life by stating that right to life embodies. Justice Bhagwati highlighted the importance of right to life by stating that right to life embodies, 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 ठीक है, embodies a constitutional value. Right to life embodies a constitutional value. A constitutional value of supreme importance in a democratic society. A constitutional value of supreme importance in a democratic society. Full stop. Change the line and write. दो PEL कैपिटल लेटर्स में लिख दीजिए, प्रोसीजर एस्टैब्लिश बाय लॉ, समझ में आ जाएगा. दो PEL, it does not give wide powers of judicial review. दो PEL does not give wide powers of judicial review. दो PEL does not give wide powers of judicial review, but the Supreme Court in Meneka Gandhi, Meneka, it's not Menka, it's Meneka, Meneka. But Supreme Court in Meneka Gandhi versus Union of India, the Supreme Court in Meneka Gandhi versus Union of India ruled that while exercising judicial review, while exercising judicial review, the court can check the while exercising judicial review, the court can check the fair, just and reasonability of a piece of legislation. The court can check the fairness, justness and reasonability while exercising, तेज जा रहा है, while exercising judicial review, the court can check the fairness, justness and reasonability, fairness, justness and reasonability of a piece of legislation. Fairness, justness and reasonability of a piece of legislation. ठीक है, अब कुछ केसेस लिख लीजिए, you can add in your mains or if they can ask, okay? So you write, सबसे पहले लिखिए सुनील बत्रा केस. सुनील बत्रा केस, राइट टू हेल्दी लाइफ, पार्ट ऑफ आर्टिकल 21. ये लिखने की जरूरत ही नहीं है, ऑल द केसेस आर रिलेटेड टू आर्टिकल 21. सो सुनील बत्रा केस, राइट टू हेल्दी लाइफ. नेक्स्ट यू राइट पीपल्स यूनियन फॉर सिविल लिबर्टीज केस. सुनील बत्रा केस, राइट टू हेल्दी लाइफ को कहा पार्ट ऑफ आर्टिकल 21. समझ रहे हैं ना, राइट टू लाइफ इंक्लूड्स राइट टू हैव अ healthy life. Then you have People's Union for Civil Liberties case. People's Union for Civil Liberties case. Non-payment of wages was held to be violative of Article 21. Non-payment of wages. अब इसमें भी कुछ है, मैंडरिन नहीं है. Non-payment of wages was held to be violative of Article 21. Non-payment of wages was held to be violative of Article 21. यानी कि अगर आप किसी को उसकी पगार नहीं दे रहे हैं तो राइट टू लाइफ का उल्लंघन है. यू आर गेटिंग दिस? ऑल दीज केसेस आर रिलेटेड टू आर्टिकल 21. ओके, नेक्स्ट यू राइट हुसैन आरा खातून वर्सेस स्टेट ऑफ बिहार. हुसैन आरा खातून, SUHUSSAIN, ARA आरा, खातून KHATOON. ओ भाई एक सेकंड रुकिए, दिस इज गेटिंग मर्कियर. एक सेकंड. हुसैन, ये एक एक्चुअली लॉ के फील्ड में इंपॉर्टेंट केस है. हुसैन आरा खातून okay, visible. Please write Hussain Ara Khatun versus State of Bihar. Right to speedy trial. Right to speedy trial. Next you write Vishaka versus State of Rajasthan. Vishaka versus State of Rajasthan. सेक्सुअल हैरेसमेंट इज अफ्रंट टू, अफ्रंट मतलब वायलेटिव कर दीजिए, इजी लैंग्वेज. सुप्रीम कोर्ट ने अफ्रंट कहा था. सेक्सुअल हैरेसमेंट इज वायलेटिव ऑफ आर्टिकल 21. सेक्सुअल हैरेसमेंट इज वायलेटिव ऑफ आर्टिकल 21. वायलेटिव ऑफ आर्टिकल 21. और लिखिए किरण बेदी केस, राइट टू रेप्यूटेशन. Kiran Bedi case, right to reputation as a part of right to right to reputation as a part of right. Reputation मतलब समझ, recognition, standing, इज्जत, आइए बैठिए. Okay, so right to reputation as a part of right to life. Next you write, this is also a very important case. Actually ये क्वेश्चन लॉ ऑप्शनल में ज्यादा पूछे, यहां नहीं, फिर भी मेंस में इफ यूल राइट यूल गेट मार्क्स. पॉल्यूटर पेज प्रिंसिपल सुना है, नाम में ही छुपा है. पॉल्यूटर पेज प्रिंसिपल. पॉल्यूटर पेज प्रिंसिपल मतलब जिसने फेंका लेज उसी को देना होगा फाइन. वेरी सिंपल. सो प्लीज राइट वेल्लोर सिटीजंस वेलफेयर फोरम केस. वेल्लोर सिटीजंस वेलफेयर फोरम. वेल्लोर, अब यू हैव सीन दैट बिल्डिंग एट राजेंद्र प्लेस, रेड बिल्डिंग, ऊपर से कूदिएगा, कहीं बच गए तो फिर पेरेंट्स को दिक्कत हो जाएगी, फिर वही राजू हिरानी की तरह भिंडी और ओके. प्लीज राइट वेल्लोर सिटीजंस वेलफेयर, वेल्लोर सिटीजंस वेलफेयर फोरम केस. ओके, प्लीज राइट polluter pays principle. Polluter pays principle और ये क्वेश्चन एक्चुअली कई बार आ चुका है, अभी मैं बताऊं. was established. ये क्वेश्चन न जाने कितने एग्जाम में, दिल्ली यूनिवर्सिटी के एमए एनवायरमेंट के भी एग्जाम है. polluter pays principle was established. This question has been asked in CLAT. This question has been asked in Delhi University MA Environment. This question has been asked in UPSC. This question has been asked in State PSC. Just आप search कीजिए. That National Green Tribunal was established to promote which article of the Constitution? That is Article 21, Right to Clean Environment. ये question आ चुका है. अब next last लिखिए MC मेहता. MC मेहता case. MC मेहता case related to the right to clean environment. Related to the right to clean environment. Okay, ठीक है. Okay, now you write one line as a ये कि right to die as a part of right to life. Right to die as a part of right to life. ये मेंस का पूरा एक क्वेश्चन हो सकता है. राइट टू डाई एज अ पार्ट ऑफ राइट टू लाइफ. ओके, जस्टिस भगवती का राजेश्वर पूछ रहे हैं दैट इज ऑफ कॉन्स्टिट्यूशन प्राइम इंपॉर्टेंस. मतलब किसी भी डेमोक्रेटिक समाज में, लोकतंत्र में, किसी भी डेमोक्रेसी में राजेश्वर, right to life is very very important. This is what Justice Bhagwati is conveying. Now we come to right to life as a part of right to right to die as a part of right to life. पहले आप अपने विचार दीजिए, फिर मैं अपने विचार दूंगा. हाँ बताइए क्या राइट टू डाई. वेरी गुड, कितनी अच्छी बात कही इन्होंने. राइट टू डाई विथ, राइट टू डाई नहीं है, राइट टू डाई नहीं है, ठीक है. राइट टू डाई विथ डिग्निटी. आसमान और जमीन का अंतर है, अभी मैं बता रहा हूं. नाउ द पॉइंट इज, पहले एक छोटे केस से शुरुआत करते हैं. देयर इज अ प्रैक्टिस इन जैन रिलीजन, वी ऑल नो दैट दिस इज संठारा और सल्लेखाना प्रैक्टिस. हु डाइड इन हिस्ट्री बुक्स? यू मस्ट हैव रेड अबाउट अ किंग हु डाइड व्हाइल प्रैक्टिसिंग दिस. चंद्रगुप्त मौर्य. Chandragupta Maurya, there was two groups, Sthalbhadru and Bhadrabhadru. So he, along with Bhadrabhadru, traveled to the dense forest of Karnataka, and there he took Santhara practice. So in Jain religion, after attaining a certain age stage of your life, you stop eating and drinking and allow your body to denigrate in a natural manner, and you die. It is said that Chandragupta Maurya, it is written in R.S. Sharma, India's Ancient Past book. It is one of the best book on ancient history. Okay, that Chandragupta Maurya took this practice along with Bhadrabhadru, who he went to southern part of the country, Karnataka jungles. So basically Chandragupta Maurya practiced this. This question has also been asked in ancient. Okay, anyways. So this practice was challenged in Gujarat High Court. That Santhara practice is violative of Article 21 because right to life does not include right to die. So the Gujarat High Court declared Santhara practice as unconstitutional and violative of Article 21 of the Constitution. So the Jain community moved Supreme Court. Supreme Court stayed the Gujarat High Court judgment, and now the Supreme Court called for the manuscripts of Jain community compiled in कहाँ compile हुई थी? हिस्ट्री में पढ़ा होगा आपने? नहीं, अभी क्लास नहीं हुई है, स्कूल में पढ़ा होगा आपने. That is, ये तो बेसिक. That is 4th century AD, Vallabhi, Gujarat. The Jain manuscripts were compiled. So the Supreme Court has called for the original manuscripts of Jain community, and they will see whether Santhara practice is an essential tenet of Jainism or not. If it is an essential tenet of Jainism, it will be saved under Article 21. तो पहले तो ये एक केस है. दूसरा केस है, right to life includes right to die or not. First case is P. Rathinam case. Supreme Court ruled that right to life also includes right to die. Right to life का part है right to die. So if right to life includes right to die, so IPC 309, बचपन से सुने क्या है 309? This is the only offense in IPC where if you are successful, you will not be punished. So if you try to commit suicide, if you are successful, you will not be punished. If you are unsuccessful in the crime, then you will be sent to jail for 1 year. Okay. So now National Mental Health Care Act 2017 says that notwithstanding anything in IPC 309, a person who commits suicide, if other contrary reasons do not exist, will be taken as a mentally ill patient, and he'll be treated, he will not be subject to any criminal, what you call, law and all. So otherwise, contrary to the other, if you say that give me a Lamborghini, otherwise I'll commit suicide before DC's office. So this, notwithstanding anything in IPC 309, if contrary reasons do not exist, but this is a contrary reason, he is a hale and hearty, but he wants Lamborghini, that is why he is commit suicide before the DC office. So you will be subjected to 1 year of jail, and they may not even save you. आप थोड़ा सा किरासन डालेंगे कि कोई बचाएगा, नहीं बचाया तो then what would you do? Okay, you have that anticipation. So Supreme Court in P. Rathinam case ruled that right to life includes right to die. The moment Supreme Court ruled that right to life includes right to die, फिर क्या हुआ? IPC 309 was declared as unconstitutional. After that, a couple was accused of abetting suicide. Gyan Kaur versus State of Punjab. So a couple was accused of abetting suicide. जैसे किसी ने बोला कि यार दिल अच्छा नहीं लग रहा, you said अरे कर ले तू suicide. So you are actually, so that couple was abetting the person to commit suicide. She went to Supreme Court, Gyan Kaur, that I was actually helping the person to enjoy his or her fundamental right, because right to life includes right to die. Supreme Court reiterated and declared P. Rathinam right to life does not include right to die, and IPC 309 again came back to life. After that, Aruna Shanbog, ये तो केस आपने सुना होगा, हाँ? कोई बात नहीं, ठीक है. So it is Aruna, Shanbaug. Aruna Shanbog actually was a lady nurse who was working in King Edward Medical College, Chem College, India ka one of the best medical, you get 200 rank something, then you get that college. So King Edward Medical College, Chem Hospital in Mumbai. So she was working in that medical college. In April 1973, she was subjected to brutal rape and what you call torture. This you must have heard about this case. Gale mein, so actually she went into permanent vegetative state. So she went into permanent vegetative state and in coma. Since she was a working nurse in a hospital, she was admitted to the same hospital, and nurses were taking care of her for last 40 years. Okay, so they were taking care because they were attached also. So a lady called as Pinky Virmani, she approached the court as the friend of the court. Okay, friend of the court, she said that she is in constant pain for past so many, more than 35 years. She should be allowed to die. That is right to die with dignity. When Pinky Virmani approached the court, before that, common cause का मतलब क्या हुआ? Common cause. Any cause which is common. So there is an NGO called as Common Cause which files PIL on common causes. Okay. कॉमन ही कॉज होगा ना. सो वन सच कॉमन कॉज PIL was filed that right to life includes right to die with dignity. This PIL was actually pending in Supreme Court, and meanwhile this lady Pinky Virmani, she approached Supreme Court to allow Aruna Shanbhog to die with dignity, withdraw the external support. Withdraw the external support and she will die within few minutes because oxygen, everything is being provided from outside. So the Supreme Court ruled that ki okay, so passive euthanasia and active euthanasia. Euthanasia in simple language means good death, mercy killing. So passive euthanasia and active euthanasia में अंतर है बहुत ही मामूली सा. Active euthanasia means you are in acute pain, you are in pain that you cannot bear that pain, but you will not die until something is injected from outside. You are in pain for long, you want to say people please kill me, but until something is administered actively from outside you will not die. So this is active euthanasia. Passive euthanasia mein you are in permanent vegetative state. The moment ilaj, treatment is withdrawn, you will die by your own. So there is, in active euthanasia, an active intervention is done from outside to make you die. In passive euthanasia, active intervention is not done, outside support is withdrawn. So Supreme Court said for the first time in Aruna Shanbhog case that okay, they said ki passive euthanasia can be allowed on case by case basis. Passive euthanasia can be allowed on case by case basis, and it will be decided by jurisdictional high court. Wherever the patient is there, the High Court shall constitute a committee comprising of a practicing medicine physician and a psychologist, okay, and other doctors, and they will give a report that present medical treatment, advancement of medical technology has not reached that level to bring this person back to normal life. You see that Banerjee in Munna Bhai MBBS? Okay, so bring that person back to life. Then the High Court, jurisdictional High Court, on case by case basis can allow the outside treatment to be withdrawn. So passive euthanasia was for the first time recognized in Aruna Shanbhog case. Then what happened? But Aruna Shanbhog's treatment was not withdrawn because the nurses of King Edward Medical College were adamant. Who is Pinky Virmani? We are taking care of her for 30 years. We don't have a problem. Who is she to have a problem? So actually it was not implemented, but a philosophy was sown. A philosophy of Supreme Court that passive euthanasia can be allowed on case by. Now the Constitution bench, now another 3-judge bench took up the matter of common cause, which was pending till 2006. Now there was an inconsistency because I have presented a paper also on this, so I know every alphabet what they have used. So uske baad they said ki there is an inconsistency between Gyan Kaur and Aruna Shanbhog. Dono case mein inconsistency hai, so it was referred to a Constitution bench. And the Constitution bench gave a landmark verdict, that is, the Constitution bench of Supreme Court established the principle of living will. Anybody who is of sound mind can go to judicial magistrate first class. There will be 2 witnesses, comma deke kehta hai, preferably independent. Matlab not family members. So anybody who is of sound mind, he can go before a joint magistrate first class, inform him that if I am not in a position to take a decision about my health, then this person will be taking a decision on my behalf. And that person will take a decision, and that will be saved in the district registry, and 1 copy will be sent to the district magistrate also. It will be saved there. When that person goes into permanent vegetative state, the person who has been empowered under the living will, he will initiate the process. First, a medical board will be, itna to UPSC, khair chhodiye, to theek hai. First, a medical board shall be constituted. They will not ask, they will just ask living will. I'll give you a definition, living will, standard definition. Phir bhi, ki first a medical board shall be constituted at the hospital where patient is undergoing treatment. Then after that, the district magistrate shall constitute another medical board under the chairmanship of chief medical officer. They will determine, you can challenge that in High Court. Okay, so this is passive euthanasia. Abhi Supreme Court ne kaha advance medical directive, all living will. Although some judges have used the term living will, some judges have used the term advance medical directive. आप interchangeably use कर सकते हैं कि कोई भी व्यक्ति जो अभी normal है, वो एक judicial magistrate first class के पास जाकर एक living will बना सकता है कि अगर मैं बीमार पड़ा तो ये व्यक्ति मेरी जगह पर सारे फैसले लेगा. एंड आफ्टर दैट ऑल्सो मेडिकल बोर्ड विल टेक अ डिसीजन एंड फाइनली डिस्ट्रिक्ट मैजिस्ट्रेट विल डिपेंड ऑन द बोर्ड ऑफ यू कैन चैलेंज इन हाई कोर्ट. सो व्हाट यूपीएससी वांट्स टू नो, द कंसेप्ट ऑफ लिविंग विल वाज गिवन बाय सुप्रीम कोर्ट इन कॉमन कॉज केस. Okay, second point is, if there is no medical directive, if there is no living will, if there is no advanced medical directive, in one of the paragraphs it is written, then the same process will be there. The nearest family members, but always the interest of the patient shall be taken care of. So first, P. Rathinam case, where right to life includes right to die. Second, Gyan Kaur case, overturned. Aruna Schonberg case, the concept of passive euthanasia was recognized. And finally, the most important judgment is, that is common cause that established the principle of living will in India. कोई भी व्यक्ति जो साउंड माइंड का है, मेजर है, वो जाकर जुडिशियल मैजिस्ट्रेट फर्स्ट क्लास के सामने एक लिविंग विल बना सकता है कि अगर मैं बीमार पड़ा तो दिस पर्सन. सो द सुप्रीम कोर्ट रूल्ड दैट राइट टू लाइफ इंक्लूड्स राइट टू डाई विथ डिग्निटी. It does not include right to die. It includes right to die with dignity, and that too the medical board shall be taking a decision in the interest of patient. अब यूपीएससी क्या क्वेश्चन पूछेगी? What do you understand by living will? Okay, what are the critically examine the concept of living will in India. So you will feed the information from पी रथिनाम से और एकदम जल्दी से क्रिस्प पे, फिर ये विल टॉक अबाउट द पॉजिटिव्स एंड नेगेटिव्स ऑफ लिविंग विल. अब मुझे आप बताइए, द विड्रॉल ऑफ ट्रीटमेंट, व्हाट आर द पॉजिटिव्स ऑफ इट? क्या क्या स्कॉलर्स क्या मानते हैं? ऐसे आप भी मानते हैं? आप खुद ही तो स्कॉलर हैं. यू आर फ्रॉम डिफरेंट, सो मेनी पीपल आर फ्रॉम डिफरेंट फील्ड्स. यू हैव ऑलरेडी प्रूव्ड योर मेटल, सम ऑफ यू फ्रॉम आईआईटीज, सम ऑफ यू हैव डन. सो व्हाट डू यू थिंक इज द पॉजिटिव ऑफ दिस जजमेंट? हाँ, first, ki anybody has a right to die with dignity. If the person is in incessant pain, endless eternal pain, that person should be given relief. Second reason is, of course it is a burden on physical, emotional and financial strain on family members. Third, we saw in corona mein always there was an option, X ko bachaye ki Y ko bachaye. Whoever was less serious, he was tried. Why? क्योंकि जो एकदम लास्ट स्टेज में, it is very tough to save that person. So with the limited resources in the country, public health state subject है कि concurrent list है? हाँ, public health is a state subject. Agriculture is also a state subject. Education is concurrent. Wildlife is concurrent. Forest is concurrent. Marriage is concurrent. Defense is union list. Land law and order is state. Agriculture state. अब public health state. Medical education concurrent. Public health is a state subject, but medical education is a concurrent subject. इसी वजह से NEET law. So who has a supremacy in concurrent list? Parliament. इसीलिए if the state legislature's law of Tamil Nadu wants to overcome the parliamentary law, it has to be approved by president. If the parliament wants to overcome, a state wants to overcome the parliamentary law on concrete list, that's a different thing. We'll see that. Anyways, so now positives ये सारे हैं कि it is a resource. Negatives क्या है? कुछ ज्ञानी लोग ये भी मानते हैं कि life is the gift of God. So who knows, tomorrow there will be an advanced medical treatment that will bring that person back to Mr. Banerjee आए थे ना वापस लास्ट में मूवी में. So first point. Second, some people say कि it is ethically incorrect. Nobody has the power to give life, so life can only be given and taken. Ethical point of view है. Third important है susceptible to misuse. Susceptible to misuse. You see, go and search on YouTube. There is a video. There NDTV का एक video है actually कि there is a lady who actually she's a doctor and she kills her father for property. मतलब अंदर जाके he was ill, so she removes the support, something all like that. Very horrific. So actually these things actually may lead to susceptible to misuse. So you have mercy killing, the idea behind mercy killing, difference between advanced medical directive and passive euthanasia and active euthanasia. What are the positives? What are the negatives? What was the contention in Aruna Schonberg case and what was the contention in common cause case? and P. Rathinam was the first case in line of this direction. So we'll write after the break, that is right to life का एक और extension. Okay, then we will see right to life का एक बचा हुआ है, that is privacy. KS Puttu Swamy versus Union of India, that is right to privacy. That also we'll see. Please. Okay, so we will be like thoda sa. This is actually क्योंकि मेंस में इसको लेकर दे कैन आस्क अ क्वेश्चन. ओके, ऐसे ही व्हेन वी हैव टेक्नोलॉजी तो so actually this is PDF from Supreme Court of India. So this is the judgment, original judgment जो Supreme Court ने लिखा है वो है. Okay, so who can, इसी तरीके से who can execute advance directive? Advance directive can be executed by an adult who is sound and healthy mind in position to communicate, comprehend. It must be voluntarily executed. ये judgment है Supreme Court का, उसी की copy है, 538 पेज का judgment है. So it should have characteristic of an informed consent. Okay, so all these things are, it shall be writing clearly what should contain. It should contain the decision relating to circumstances, specific term, mention the executor, कौन action लेगा. Getting my point? So this is, it should disclose the executor, how it should be recorded, executed. To ये लिखा है two attesting witnesses, comma देके preferably independent. Okay, so before judicial magistrate first class, judicial magistrate first class. So ये actually ये है, समझ रहे हैं ना, when and by whom all these things are given. ठीक है, तो लिखते हैं, लिखिए, लिखिए, टॉपिक तो आपने लिख रखा है ना, right to life as a part of, right to die as a part of right to life. Write further, please. The Supreme Court in P. Rathinam versus Union of India the Supreme Court in P. Rathinam versus Union of India ruled that the Supreme Court in P. Rathinam versus Union of India ruled that right to die, कोई बात नहीं, आराम से बैठिए, right to die is an integral part of, the Supreme Court in P. Rathinam versus Union of India ruled that right to die is an integral part of right to life. Thus IPC 309 was thus IPC 309 was declared unconstitutional, thus IPC 309 was declared unconstitutional. Okay, did we start a bit early? Huh? Okay, so please write further. Next you write Gyan Kaur versus State of Punjab. Gyan Kaur versus State of Punjab. Gyan Kaur versus State of Punjab. Right, the Supreme Court overturned the previous judgment. The Supreme Court overturned the previous judgment. The Supreme Court overturned the previous judgment. And ruled that the Supreme Court overturned the previous judgment and ruled that right to the Supreme Court overturned the previous judgment and ruled that right to life does not include right to die. Right to life does not include right to die. And right to life does not include right to die, and IPC 309 was restored, and IPC 309 was restored. IPC 309 was restored. Okay. Next you write the so पहले क्या कौन सा केस था? पी रथिनाम वर्सेस यूनियन ऑफ इंडिया, फिर था ज्ञान कौर वर्सेस स्टेट ऑफ पंजाब. ओके, दिस इज डन. नेक्स्ट इज सो नेक्स्ट इज अरुणा शान बॉग. प्लीज राइट अरुणा शान बॉग केस. लास्ट लाइन क्या लिखी थी आपने? वजरी से. ठीक है, इसको सिनॉप्सिस में लिखते हैं. लिखिए अरुणा, ARUNA, अरुणा, SHANBAUG, शान बॉग केस. ओके, प्लीज राइट द सुप्रीम कोर्ट रूल्ड दैट. क्या वो इस केस में क्या इशू है? द सुप्रीम कोर्ट रूल्ड दैट passive euthanasia can be allowed. The Supreme Court ruled that passive euthanasia can be allowed. Passive euthanasia can be allowed in certain circumstances. In certain circumstances, to be decided by jurisdictional high court. To be decided by jurisdictional high court. Passive euthanasia can be allowed in certain circumstances. ठीक है? To be decided by jurisdictional high court. Jurisdictional high court मतलब क्या हुआ? जहां भी पेशेंट है वो जिस भी हाई कोर्ट के jurisdiction में आता है. अंडमान एंड निकोबार comes under which high court? Calcutta High Court. Lakshadweep comes under which high court? Kerala High Court. You have what you call so Delhi. Which high court? Which union territories have their own high court? Delhi and Chandigarh. So Chandigarh has its own high court. Chandigarh comes under the jurisdiction of Punjab and Haryana. Delhi and Jammu and Kashmir. Article 241 of the Constitution empowers that. Okay, so that is there. So and ठीक है, अब इसको बाद में देखेंगे. फिलहाल jurisdictional high court. So what did you write? Okay, the full stop. Then you write thus for the first time apex court acknowledged. Thus for the first time apex court acknowledged passive euthanasia. Thus for the first time apex court acknowledged passive यूथेनेसिया. ठीक है, अब फिर नीचे आइए और लिखिए देयर वाज अ पेंडिंग PIL by common cause. There was a pending PIL by common cause. There was a pending PIL by common cause where they argued the right to where they argued right to life includes right to die with dignity. Includes right to die with dignity. Okay, next please write. Thus the Supreme Court delivered a landmark verdict. Okay, thus the Supreme Court delivered a landmark verdict. Full stop. आगे लिखिए. You write passive euthanasia is removal of life support mechanism. Removal of life support mechanism from those who have gone into permanent vegetative state, who have gone into permanent vegetative state, जो कोमा में चले गए, who have gone into permanent vegetative state, so as to who have gone into permanent vegetative state. कोई बात नहीं, कसम से कोई बात नहीं. You just need one reason on earth, 1,000 reasons not to study, one reason to कुछ भी. वो बीच में बाद में आ गया. He is already embarrassed. कोई मेरे फैमिली में anybody commits a mistake, I never say anything. If first I'll help that person for 2-3 months. When that person becomes normal, after 3 months, then I'll so एकदम. और कोई जब तक कोई बार बार गलती नहीं कर रहा है, उस गलती को ध्यान भी नहीं देना है. अगर एक बार है गलती से हो गया, पर हां कुछ भी हो, उधर हवा तेज चल रही है ट्रॉपिकल, तो आज नहीं पढ़ेंगे. आज उसका बर्थडे है, कल उसके दूसरे भाई का बर्थडे है, तो इसका बर्थडे है, ठीक है. कुछ अभी हो जाए, हल्का सा ऐसे गिर जाए पेन, बस नहीं पढ़ना है. तो क्या है भाई, कुछ कितनी चीजें हैं, टेलीग्राम, इंस्टाग्राम, स्नैपचैट, ड्रैगन चैट, ठीक है. एनीवेज, व्हाट वाज द स्टेटमेंट? सो एज टू. अच्छा ये बताइए, विड्रॉल ऑफ ट्रीटमेंट. अब इसका आप मुझे जवाब देंगे. विड्रॉल ऑफ ट्रीटमेंट हु हैज गॉन इनटू परमानेंट वेजिटेटिव स्टेट. Withdrawal of treatment who has gone into permanent vegetative state so as to allow that person to die with dignity in natural course. So as to allow that person to die with dignity in natural course. So as to allow that person to die with dignity in natural course. Okay, full stop. ये तो हो गया passive euthanasia. You have to briefly write about active euthanasia also. Please write active euthanasia is intentional act of causing death. Active euthanasia is intentional act of causing death to a person. Active euthanasia is intentional act of causing death to a person who is experiencing unbearable pain. Unbearable pain, but would not die without an active external support. अब इसमें भी रिसर्च है. पैसिव फिजिशियन असिस्टेड सुसाइड वो अलग है, ठीक है. एक्टिव एक्सटर्नल सपोर्ट, इसका भी क्लासिफिकेशन है. फिजिशियन असिस्टेड सुसाइड, एक में क्या है, फिजिशियन जब जस्ट बता देगा वहां रखिए दवा. Getting my point? So he actually will not administer. एक में फिजिशियन बोलेगा लाओ मैं तुम्हें मारता हूं, चिंता मत करो. So anyways, getting my point. So active euthanasia and physician assisted suicide भी एक टर्म है. उसमें फिजिशियन बस बता देता है वहां रखिए दवा, खा लो. Getting my, anyways, please write. हाँ, पॉजिटिव अभी आएंगे ना. पॉजिटिव बिल्कुल लिखेंगे, पॉजिटिव लिखेंगे, नेगेटिव बिल्कुल, नेगेटिव नहीं चैलेंजेस लिखेंगे, बिल्कुल लिखेंगे, वो तो लिखेंगे ही. अभी पहुंचे तो वहां. हाँ, आपने सोच कैसे लिया, वो तो मेन है. यूपीएससी तो क्वेश्चन वही पूछेगी. ये सब चीजें तो यूपीएससी इज लीस्ट कंसर्न, पैसिव एक्टिव यूथेनेसिया. बट यूपीएससी विल आस्क यू व्हाट आर द चैलेंजेस, प्रोज एंड कॉन्स रिलेटेड टू द सुप्रीम कोर्ट जजमेंट ऑन पैसिव यूथेनेसिया. दे डू नॉट वांट टू नो. वो तो ऐसे ही मैंने बता दिया कि फिर कोई न्यूज़पेपर में पढ़ेगा. हाँ, एक क्वेश्चन किसी ने पूछा इस बैच में, सारे बैचेस में. ओके, दैट द फर्स्ट ऑफ ऑल अ केस हैज बीन फाइल्ड इन सुप्रीम कोर्ट टू डिक्लेयर रिलीजियस माइनॉरिटीज ऑन स्टेट लेवल. ओके, सो व्हाई अ केस हैज बीन फाइल्ड इन सुप्रीम कोर्ट? Because they are not If they are already declared as religious minorities in every state, so why, तब तो कोई जरूरत नहीं है. Has a case filed in Supreme Court that allowed people to live. They are already living. There is no need to file a case in Supreme Court. So a case has been filed in Supreme Court. It means that they are not declared on religious minorities on state basis. अब उसमें क्या हुआ? Center has filed a new affidavit. We don't have a problem. You go ahead and declare religious minorities. ठीक है, कोई बात नहीं. Till now they were not declared. और कहीं से एक खोज के aberration exception लेके आया कि महाराष्ट्र में जूस को religious minority हो सकता है, एक exception हो, पर as if now no state has declared any religious community as religious minority. अब उसमें center has filed a new affidavit. तो ये एक नया मूव है. So नया मूव है. Center has filed an affidavit कि we don't have a problem. You go ahead and declare religious minorities on state basis. तो ये एक नई चीज हुई ना. ये नया एक state center का stand है. ठीक है, it's very good. Now National Commission for Minorities Act center चाहे तो amend कर सकता है. Either it can amend or the center can allow the state. Because the act does not prohibit. We should wait for the final Supreme Court. Question is कि religious minorities, अब उसमें कुछ लोगों को confusion है. Religious minorities till now are not determined on state basis. Now a new stand, honorable, the present government has taken a new stand that we don't have a problem. States go ahead and recognize any community as religious minority. Ab the Supreme Court will deliver a verdict. Okay, so abhi tak kya hota aa raha hai? Abhi tak religious minorities are only determined on national basis. Abhi tak wahi hota hua aa raha hai. Aur Jews are not religious minorities. Jews are not religious minorities under National Commission for Minorities Act 1992 and National Commission for Minority Educational Institution Act. Jews have not been declared as religious minorities. Although somebody gave an exception कि महाराष्ट्र में हो सकता है एक exception हो, aberration हो, पर on the whole Hindus are, there is not a single medical college in the country in any state established by Hindus where 50% of the seats are reserved for Hindus. In Bihar you have Mata Gujri Medical College, so for some religion. Katiyar Medical College, 50% seats are reserved for Muslims. Jamia Millia Islamia, 50% seats are reserved for Muslims. St. Stephen's College versus University of Delhi, St. Stephen's College, 50% seats are reserved for Christians. There is not a single medical college in the country where 50% seats are reserved only for Hindus. क्योंकि as if now they are not declared. अब एक नया मूव है, हो गया, कोई बात नहीं. Center has taken a new stand. How can we predict that what will be the stand? You have got your answer. What will be the stand of tomorrow center meeting? अब best example है Jamia Millia Islamia. Jamia Millia Islamia was not a minority institution till 2009. In 2009, National Commission for Minority Educational Institution, एक commission है, recognized Jamia Millia as a minority institution. So at that time the government were different. Now the central government has filed an affidavit in Supreme Court. Central government has filed an affidavit in Supreme Court because somebody challenged the status granting of minority to Jamia Millia Islamia. Because it was established by an act of parliament in 1988, although it came into being in 1920 during the non-cooperation movement when Gandhiji called for Desi University, Desi education. So Jamia Millia Islamia was established in Aligarh. And later on it was transferred to Karol Bagh, and then it was shifted to the present location, that is in Okhla. And 1988 it was given status of a central university by an act of parliament, and in 2009 it was given minority status. Now the present government has taken a different stand. So it is just the government, as if now religious minorities are not defined on state basis. Ab chunki center has no objection, so states may go ahead and define religious minorities on state basis. This question actually has been asked in all the batches. Kyunki there is a consistent stand ki Hindus are not, or I told you ki this is going to happen. On that day when we were discussing, I was 100% sure. Kyunki you cannot deny a minority Hindus, you cannot deny them to be minority. In at least 12 states they are minorities. Many northeastern states, Jammu and Kashmir. Okay, so you cannot deny them their constitutional right. ये आज नहीं तो कल होना ही था. Now the things have become clear and they can establish medical college and reserve 50% seats only for Hindus. So now it can be done like it is done for Jamia or St. Stephen's College or Mata Gujri Medical College or KMCH medical colleges. ठीक है? तो क्या लिखा आपने? Without any. Now you write. Euthanasia means mercy killing or good death. Euthanasia means mercy killing or good death. Okay. Now you write. The Supreme Court in common cause case the Supreme Court in common cause case ruled that the Supreme Court in common cause case ruled that advance medical directive, the Supreme Court in common cause case ruled that advance medical directive or living will, ये आपके सामने है सुप्रीम कोर्ट का जजमेंट, एडवांस मेडिकल डायरेक्टिव और लिविंग विल, देखिए ये सामने, यही जजमेंट है, ये एक सिनॉप्सिस नहीं है, दिस इज द ओरिजिनल जजमेंट ऑफ सुप्रीम कोर्ट, पेज नंबर 170. एडवांस मेडिकल डायरेक्टिव और लिविंग विल कैन बी एग्जीक्यूटेड बाय can be executed by an adult of sound and healthy state of mind, can be executed by an adult of sound and healthy state of mind, comma, ये लिखना है आपको मेंस क्या, voluntarily, ठीक है, विदाउट एनी कोरिजन और कंपल्शन, वॉलेंटरीली यानी अपनी मर्जी से, स्वेच्छा से, विदाउट एनी कोरिजन और कंपल्शन, विदाउट एनी कोरिजन और कंपल्शन, ओके, क्लियरली indicating without any coercion or compulsion, clearly indicating, ठीक है, clearly circumstances in which withdrawal of medical treatment can be resorted to, clearly indicating circumstances in which withdrawal of medical treatment can be resorted to, withdrawal of medical treatment can be resorted to. Suyesh Agarwal is asking, AMU has 50% reservation, why it is not called a minority university? Not a single seat in Aligarh Muslim University is reserved for any Muslim. I am again revising that on the camera, there is not a single seat is reserved for Muslim in Aligarh Muslim University. It is not a minority university declared by Allahabad High Court, case is pending in Supreme Court. Only the seats are reserved for those who have done their qualifying exam from AMU. So if you are appearing for medicals, if you have done your +2 from AMU, 50% seats are reserved for you. But religious based seats are not reserved in Aligarh Muslim University. It is not a minority university. But Jamia Millia Islamia 100% is a minority university. 50% seats in courses are reserved for only for, not for minorities, but for religious minorities only, Muslims. St. Stephen's College, it is not. So there is a confusion. Okay. So लिखिए क्या, लास्ट क्या लिखा आपने? Medical treatment can be resorted to. Last लिखिए, it has to be made. It has to be, you must write this in your mains answer. What are the characteristics of an advanced medical directive? They can ask a mains question. You will write all this point wise. It must contain, it has to be attested in the presence of two attesting witnesses. ठीक है, कुछ भी लिख दिया, it has to be attested, made, कुछ भी, in the presence of two attesting witnesses, preferably independent. Preferably independent. Okay, countersigned by, preferably independent, countersigned by judicial magistrate first class. Khatam. काउंटर साइन, जब आप ज्वाइन करते हैं तो जुडिशियल मैजिस्ट्रेट सेकंड क्लास रहते हैं, 3 साल बाद आप बनते हैं फर्स्ट क्लास. ओके, सो जुडिशियल मैजिस्ट्रेट फर्स्ट क्लास. So this is the original copy of the judgment of Supreme Court, that who can make an advance medical directive, what all things can be contained, all these things they can ask in print. Now you write arguments in favor of passive euthanasia. Please write arguments in favor of passive euthanasia. Arguments in favor of passive euthanasia. A, arguments in favor of passive euthanasia. ठीक है, A. See, why I am telling you, because if you are talking about Article 30 and by mistake if you give a false example that AMU is a minority university or BHU is a university, where not a BHU is a pure secular university. BHU is a even inside the campus it's a purely secular university. Not a single seat or any positive thing is done in favor of Hindus, Muslims, Sikhs. So anybody can take admission. उसी तरह AMU में not a single seat, but in Jamia, yes, there is it is a religious minority institution. Okay, so you must be factually correct. ठीक है. Next point, what did you write? In favor. अब आप मुझे बताइए, what are the arguments in favor of passive euthanasia? First of all, please write, everybody has a right to die with dignity. Everybody has a right to die with dignity. Everybody has a right to die with dignity. Rather than being in endless pain. Okay, next you write B. It brings an end to the physical, mental and financial strain on the relatives and family members. कुछ भी लिख सकते, family members, physical, mental and financial strain on family members. Okay, next point you write, it is also necessary बताइए, और आप मुझे पॉइंट बताइए, क्यों आपको लगता है कि आनंद बैनर्जी शुड डाई? Why do you feel that Anand Banerjee should die? हाँ, ओके, एक एक करके बोलिए. मेडिकल इमरजेंसी में, कोविड में हमने देखा कि जो लिमिटेड बेड्स है, स्पेन, इंडिया ने तो मतलब वी परफॉर्म रियली वेल. द मैग्नीट्यूड ऑफ पॉपुलेशन वी हैव एंड द डेथ्स, ऑफ कोर्स सेकंड वेव वाज वेरी डेंजरस, बट स्टिल वी हैव परफॉर्म्ड बेटर. Okay, and being a tropical country with densely population, less medical support, the country was alarmed. People were standing. Everybody was actually in one. It reflects the spirit of India was best reflected during the COVID times. We have proved. Everybody, you see how the poor people, everybody was doing the best possible they can. Okay, and of course the government has done, but there may be certain things, but they have done to the best. Okay, so next you write, what did you write? It is necessary to ensure better allocation of health resources. It is necessary to ensure better allocation of health resources so as to save another life where the probability is very high. किसी का बचना ज्यादा तय है, probability is very high. Okay, now you write major challenges. What are the major challenges? सबसे पहला जो है, सबसे पहला आर्ग्यूमेंट क्या है? religion कि life is the gift of God. So ये एक और religion is a major. Please write life is a gift of God and it cannot be deliberately terminated. Life is a gift of God and it cannot be deliberately terminated by withdrawal of treatment. नेक्स्ट पॉइंट लिखिए, बताइए क्या? हाँ, ससेप्टेबल टू मिसयूज फॉर पेक्यूनरी गेन्स. ससेप्टेबल टू मिसयूज कर दीजिए, छोड़िए, समझ में आ जाएगा. ससेप्टेबल टू मिसयूज. सी, और बताइए क्या है? हाँ, इट इज अनएथिकल, तो रिलीजियसली अनएथिकल. ओके, यू से कि इन अ लिबरल डेमोक्रेटिक सोसाइटी लाइफ इज द सैंक्टिटी. एक पॉइंट बहुत इंपॉर्टेंट रेज करता है कि सैंक्टिटी ऑफ लाइफ इज गेटिंग डिक्रीज्ड. सो प्लीज राइट, इट इज अनएथिकल एंड डिक्रीजेस द सैंक्टिटी ऑफ लाइफ. It is unethical and decreases the sanctity of life. It is unethical and decreases the sanctity of life. बस यही ना क्वेश्चन बीच बीच में. ये तो मैं जो क्वेश्चन मैंने जवाब दे दिया है, फिर से वही क्वेश्चन पूछते हैं. ठीक है. It is unethical and decreases the sanctity of life. और बताइए. हाँ, ये एक बहुत ही इंपॉर्टेंट है कि मुन्ना भाई सेज, आपको कैसे पता कि ये ठीक? You're getting. So who can predict a future medical advancement that actually can bring that person back to normal life? So please write, any future medical advancement that can bring the person back to life, normal life actually, any future medical advancement that can bring the person back to normal life cannot be predicted. Any future medical advancement that can bring the person back to life cannot be predicted. Okay, आपको कैसे पता कि कल ऐसी टेक्नोलॉजी? Yesterday tuberculosis was a deadly disease. अब tuberculosis, huh? So it's like if you test, you'll get to know. Okay, so the point is, so now it has become common flu. पहले common flu से, why we are not, what is the biggest problem of sentinelese? So if they come, they do not have immunity. Okay, so this is, now you please write a very important verdict. A mains question has already been asked, that is right to privacy. Please write right to privacy. First we'll understand, then we'll write. हाँ, पूछिए. हाँ, एक्टिव यूथेनेसिया, क्या एक्टिव यूथेनेसिया? उसके क्यों पैसिव यूथेनेसिया पे जजमेंट आया है ना सुप्रीम कोर्ट का. एक्टिव यूथेनेसिया के क्या चैलेंज? आप लिख दीजिएगा कि गलत है. ओके, सो क्यों नहीं लिख सकते हैं? गलत है इसीलिए तो सुप्रीम कोर्ट ने गलत कहा है. हाँ, अब ऐसे नहीं लिखिएगा गलत है और स्माइली बना दिया, ऐसा नहीं करना है. ठीक है, ऐसा बिल्कुल नहीं. कुछ भी लाइक और नीचे लिख दिया कुछ भी. सो इट इज, हाँ, देन दे विल राइट चाय पी लो. So it is like right to privacy. Okay. So actually the Supreme Court, I have, see, these are very beautifully written judgments. So from a legal perspective, it is a matter of, it is actually a delight. It is a treat to read those judgments. This is also one of them, that is right to privacy. The Supreme Court never ever before actually categorically declared that right to privacy is a part of right to life. Debate शुरू कहां से हुई? Debate शुरू हुई, we'll understand why this debate started. वही बात है ना, फिर तो डाउट सेशन बन जाएगा. मतलब क्वेश्चंस कुछ आते रहते हैं. Getting my point? So I want to take them. Okay, I'll try to take them. Okay. So please explain the common cause case. This I am repeating. There is a person who is in permanent vegetative state. He is in coma. If you remove oxygen, within 5 to 6 minutes, that person is likely to die. Or a person can say that I will not take treatment if I go into a permanent vegetative state, so that allow me to die with dignity. So whether the right to life includes right to die with dignity, and knowing fully well that the person will die, can the family members allow to be the thing to be withdrawn outside support? This was asked by Supreme Court by common cause. Supreme Court ruled that right to life includes right to die, and under two circumstances. One, कोई भी इंसान जब सेहतमंद है, यानी when he is in healthy state, he can go to the magistrate and make a will. एक ऐसा will बना देगा कि अगर मैं permanent vegetative state में गया, if I go into a permanent vegetative state, this person will take a decision on my behalf. So that is advance medical directive, and under these circumstances, since I will not be into my senses, so please withdraw my outside support. If there is no advance medical directive, then also the medical board, one at the hospital level and finally the big one, that is at the district level, will decide, and then advance medical support will be withdrawn and the person will be allowed to die. इससे पहले ऐसा प्रोविजन नहीं था. नाउ द सुप्रीम कोर्ट हैज अलाउड कि यू कैन मेक अ लिविंग विल एंड डिक्लेयर योरसेल्फ कि अगर मैं ऐसे स्टेट में गया तो दिस पर्सन विल टेक अ डिसीजन एंड प्लीज वेदर माय सपोर्ट विल बी विथड्रॉन और नॉट, एंड फाइनली इट विल बी विथड्रॉन. सो दिस इज द कॉमन कॉज केस. इंपॉर्टेंट है पैसिव यूथेनेसिया के पॉजिटिव नेगेटिव, एंड Aruna Schonberg case में first time passive euthanasia was declared, and the position of IPC 309. So IPC 309 completely has been taken off the law book? No, it is still a valid thing. Only National Mental Health Care Act 2017 has diluted it to the extent of maximum possibility. अभी उसको dilute कर दिया है, लेकिन repeal, पार्लियामेंट को अगर रिपील ही करना था चुटकी में आईपीसी 309 को रिपील कर देता. फार्म लॉज को रिपील किया ना सिंपल मेजॉरिटी से, रिपील नहीं किया, एक नया लॉ पास करके बाय पासिंग अ लॉ एक्चुअली उसको डाइल्यूट किया. ओके, नाउ वी हैव राइट टू प्रिवेसी. So first the debate started when the Congress government way back in 2012, although this was mooted by Mr. Advani when he was home minister, कि everybody should have a biometric number. Okay, so the government established Unique Identification Authority of India. Okay, and started collecting biometric details of everybody who stays in India. Of course, Aadhaar is not a citizenship document. Anybody who stays in India can get an Aadhaar. So this project started, and after that the government changed, the new government came, and the logic behind this project was कि, for example, for every individual, from richest man in the country to anybody, 2.6 lakh rupees of tax exemption is given to everyone. For example, just you understand how, थोड़ा पीछे से जाते हैं, कोई आदमी 1 करोड़ कमाता है साल का, somebody is earning 1 crore, somebody is earning 10 lakh. So the point is, 1 करोड़ भी जो कमाता है, his income, taxable income would also be 97.5 lakh. क्योंकि 2.5 लाख जो exemption है वो सबको है, गरीब अमीर सबको है, and his income would be taxable income. फिर whatever exemptions and all, I don't want to go deep. So now imagine a situation where this person has 5 different PAN cards. P Kumar, Pradeep Kumar, Pradeep KR, okay, Pardeep KR, okay, and PKR. Okay, so this person has 5 PAN card linked to 5 different accounts. So what will happen? इस बंदे को हर एक अकाउंट पे और हर पैन कार्ड पे 2.5 लाख रुपए का टैक्स एग्जेम्पशन मिलेगा. वो तो सबको है, अमीर गरीब सबकी पहली 2.5 लाख रुपए की इनकम, आप 100 करोड़ के मालिक रहे या 10 लाख रुपए के, सबको पहला 2.5 लाख रुपए एग्जेम्प्टेड है. सो ही विल गेट बेनिफिट ऑफ 2.5 lakh in all the PAN cards. So he will actually save his tax by 10 lakhs. So the government of India said every PAN card should be linked with Aadhaar. अब P Kumar, PK Kumar और PKR सबको मिलेंगी एक ही आधार. Okay, कि they have to, all of them have to have only one. Now they can get 2.5 lakh only. So who, from where the money will be saved? From where the money will be saved? पैसा कहां से बचेगा? किसका पैसा बच रहा है? जो ये टैक्स चोरी हो रही थी तो किसका बच रहा है? Consolidated Fund of India से. Second point, Vinod is a student. he has applied for scholarship or प्री मैट्रिक पोस्ट मैट्रिक स्कॉलरशिप. उसने बेस्ट एग्जाम्पल, हर घर का एग्जाम्पल, हटाइए इसको, एलपीजी. एवरी हाउस होल्ड, एवरी अपर मिडिल क्लास, लोअर मिडिल क्लास और मिडिल क्लास हाउस होल्ड हैड एटलीस्ट 5 एलपीजी कनेक्शन. हर एलपीजी कनेक्शन पे सरकार, हर एलपीजी कनेक्शन पे सरकार 450 रुपए सब्सिडी दे रही थी. एवरी एलपीजी कमी, एवरी एक सिलेंडर से काम चलता है. एक तो पड़ोसी, 2-4 तो वही ले जाते हैं. ओके, सो द पॉइंट इज every now LPG, every LPG connection government was giving 450 rupees subsidy. पहले साल में ही गवर्नमेंट को 5600 करोड़ का फायदा हुआ और वो बढ़ता जा रहा था. So now the government said 5600 or some more than that, I don't know the exact number, even more. Now the government said कि we will give subsidy only if you link your LPG connection with Aadhaar. So every household having 5 connection, every cylinder 450 rupees per month, government is giving 2000 rupees सब्सिडी. अब 4-5 कनेक्शन मिलाकर यू लिंक इट विथ आधार, सो यू विल गेट सब्सिडी ओनली ऑन 1 सिलेंडर. और रेस्ट 4 जो है उसमें मार्केट प्राइस पे खरीदिए, कोई प्रॉब्लम नहीं है. पे 950 रुपीज. एंड नाउ द गवर्नमेंट सेड कि वी विल नॉट गिव सब्सिडी ऑन सिलेंडर, वी विल गिव सब्सिडी इन योर अकाउंट. यू बाई सिलेंडर एट द मार्केट प्राइस. अब हु सेव्ड द मनी? Consolidated Fund of India. So for this purpose, the government of India, to save such subsidy, actually I participated in debate in 2013. Ritika Khera ma'am from IIT Delhi economics department, she was actually there. I said, so there was a project launched that was Aadhaar enabled benefit transfer, AEBT, जो Aadhaar enabled benefit transfer होगा. After that, a retired judge of Karnataka High Court, Mr. K.S. Puttuswamy, he challenged the validity of Aadhaar, that you are forcing me to link my PAN card with Aadhaar. If I want LPG subsidy, I have to give my Aadhaar number. And most importantly, if I want scholarship and any other benefit or any other benefit any other or from government, so I have to give my Aadhaar. So he challenged, and this is invasion of my privacy by taking my iris, retina, hand, everything. So actually you are violating my right to privacy. So when the case was going on, the first thing which the Supreme Court asked in first few what you call meetings, hearings, they said that which authority is collecting the biometrics? So it's Unique Identification Authority of India. Usko to statutory status bhi nahi hai. It was just an executive body by a resolution passed by Government of India. Immediately government tabled a bill in parliament, Aadhaar bill, or certified it as money bill, because the government was not having majority in Raj Sabha. Aadhaar bill was tabled, and Aadhaar bill was tabled as money bill, and it was passed when the case was actually going on in Supreme Court. So Supreme Court में एक case था, and the case was related to Aadhaar. उससे भी बड़ा question, whether right to privacy is a part of right to life or not. So this was the question, and Aadhaar was a sub question. So in between, when the case was going on, government passed Aadhaar Act as money bill. Another case was filed, whether certification of Aadhaar as money bill is constitutionally valid or not. We'll see this in Parliament chapter. Abhi usme nahi jana hai. Now the Supreme Court delivered a landmark verdict. K.S. Puttuswamy versus Union of India. The certification of Aadhaar bill as money bill is constitutionally valid. First point. Second point, the Aadhaar project was held to be valid, but biometric details cannot be asked by private companies. तुरंत क्या हुआ? जितने Airtel, Reliance, Vodafone, all of them by February they have fixed कि उस दिन तक if you will not link with Aadhaar, we will actually disconnect your connection. Supreme Court ने section 57 unconstitutional कि private companies cannot force anybody to share Aadhaar number. So the Supreme Court, Aadhaar तो एक issue था, Supreme Court upheld the validity of Aadhaar, but ruled that right to privacy is an implicit part of right to life. अब दूसरा क्वेश्चन आया, whether right to privacy is a absolute right or qualified right. Absolute right मतलब यूएस में अभी 2 साल पहले बहुत ही फेमस केस हुआ. A person was involved in a terrorist activity. He was using an Apple phone. Some of you must have heard. The FBI, Federal Bureau of Investigation, kept begging Apple Incorporate कि इसको जल्दी से डिकोड करके. Apple did not decode. यही तो हमारा यूएसपी है. What happened later is not known. But in India, whether the right to privacy is an absolute right or qualified right, Supreme Court said no. It is not absolute. It can be infringed in the interest of security of state integrity of India. On these grounds, your fundamental right to privacy can be infringed. Now the Supreme Court gave three doctrines. Whenever your right to privacy is violated, it can only be violated by law. So there should be a law that must approve the action. For example, Indian Telegraph Act 1888 empowers the Home Secretary to actually order phone tapping. So it must be backed by a legislative provision if your privacy is to be. Second thing Supreme Court said, there should be doctrine of proportionality. मतलब मॉल सोसाइटी से एक साइकिल चोरी हो गई. A cycle got stolen. Everybody's phone is being checked. So the purpose for which the phone is checked is very small than the privacy that is being invaded. So the privacy, if it is invaded, the purpose should also be that big. So there must be doctrine of proportionality. To what extent your privacy can be invaded depends upon the cause for which it is being invaded. And the law shall be checked through the prism of justness, arbitrariness and reasonability. So the Supreme Court introduced कि नहीं, right to privacy is, और Supreme Court ने कहा बहुत सी बातें कही, right to sexual orientation, right to having a healthy life, right against the details of your family. All these things are important facets of privacy. So right to privacy is first time established, is an important part of right to life, although it is not absolute but qualified. The state can infringe if there is a legislative mandate and doctrine of proportionality. The purpose for which your right is being invaded is directly proportional to the right, मतलब to the extent in which your right is actually being invaded. So right to privacy को लेकर, और क्यों आया, इसके reason था, because it all started with Aadhaar project, and now the Aadhaar Unique Identification Authority of India has a statutory backing. Yes. After the passage of Aadhaar bill, now it has a statutory backing, and now the law has been passed, although it was certified as money bill, and once it is certified as money bill, Raj Sabha has no powers. Still, the certification of Aadhaar bill as money bill was held to be constitutionally valid. So this is the position of right to life in India. And what is the name of the case? Although uska naam hai privacy case or Aadhaar, what you call Aadhaar case, but the real name is K.S. Puttuswamy versus Union of India, a retired judge of Karnataka High Court. He actually filed a case. So please write right to privacy. Right to privacy. Right, K.S. Puttuswamy versus K.S. Puttuswamy versus Union of India. Put an underline and write. Right to privacy was firmly established as a part of right to privacy was firmly established as a part of right to life. Right to privacy was firmly established as a part of right to life. The Supreme Court also ruled that right to privacy is also a natural right. Right to privacy is also a natural right. Is also a natural right. Full stop. Then you write, it is also protected under Article 14, 19 and 21. Protected under Article 14, 19 and 21. आपको एक बात मालूम है, हर जगह लिखा होता है यू आर अंडर सीसीटीवी सर्विलांस. क्यों लिखा रहता है? इंफॉर्मेशन टेक्नोलॉजी एक्ट 2000, इफ यू आर बीइंग रिकॉर्डेड यू शुड बी informed. That is why it is written everywhere, you are under CCTV surveillance. When you make a call to those executives sitting over there and taking multinational telephone operators, your call may be recorded for training and monitoring purpose. So they are actually informing you that your call is being recorded. So this is Information Technology Act 2000. When you are being recorded or you are being filmed, you must be informed. Okay, that is a violation of your privacy. You must be informed. Okay, you write further. What was the last statement you wrote? Then you write, right to privacy has a wider dimension. Right to privacy has a wider dimension, including bodily autonomy, bodily autonomy, bodily autonomy, family, comma, marriage, bodily autonomy, family, comma, marriage, privacy of choice, privacy of choice, and also right to be let alone, and also right to be let alone. Change the line and write, RTP is not an absolute right per se. RTP is not an absolute right per se. RTP is not an absolute right per se, and it can be restricted. RTP is not an absolute right per se, and it can be restricted in the interest of the state. RTP मतलब right to privacy is not an absolute right per se. Per se मतलब कहने को समझे? Right to privacy is not an absolute and it can be restricted in the interest of security of state. Okay, put a dash and write semicolon and write A, या ब्रैकेट में लिखिए, put a dash semicolon, ब्रैकेट में लिखिए three conditions. अब आप मुझे बताइए कौन कौन से तीन कंडीशंस हैं जब आपकी privacy violate होगी. When your privacy is violated, what are the three conditions that must be there? What is the first and most important condition? नहीं, security of state तो ground है, पर जब violate करेगा तो क्या होना चाहिए? Backed by a लेजिस्लेटिव मैंडेट. कोई एक ऐसा नहीं कि किसी ऑफिसर ने बोला कि अच्छा चलो इसका फोन टैप कर लो, नहीं. इट शुड बी बैक्ड बाय एक लॉ होना चाहिए जो उस ऑफिसर को एम्पावर करे कि इसका फोन टैप करो. सो इट मस्ट बी बैक्ड बाय अ लेजिस्लेटिव. एक लॉ इस चीज की इजाजत देना चाहिए, एग्जीक्यूटिव ऑर्डर नहीं. सो प्लीज राइट, इट मस्ट बी बैक्ड बाय अ लेजिस्लेटिव मैंडेट. एग्जाम्पल लिख लीजिए, इंडियन टेलीग्राफ एक्ट. इट मस्ट बी बैक्ड बाय अ लेजिस्लेटिव मैंडेट. इट मस्ट बी बैक्ड बाय अ लेजिस्लेटिव मैंडेट. समझ रहे ना बात को? यानी कभी भी आपकी प्रिवेसी वायलेट होगी, इट मस्ट बी थ्रू अ स्टैट्यूटरी और अ कॉन्स्टिट्यूशनल प्रोविजन. किसी के कहने से, आपकी एग्जीक्यूटिव ऑर्डर से नहीं. इंडियन टेलीग्राफ एक्ट एम्पावर्स द होम सेक्रेटरी टू ऑर्डर फोन टैपिंग. सो देयर इज अ लेजिस्लेटिव मैंडेट. समझ रहे हैं ना? लॉ और एग्जीक्यूटिव ऑर्डर में अंतर समझ रहे हैं ना? लॉ मींस अ पीस ऑफ लेजिस्लेशन पास बाय स्टेट और लेजिस्लेचर और पार्लियामेंट. Executive by ministry, any order. Next you write, it must be proportionate to the cause. It must be proportionate to the cause. इसी ब्रैकेट में लिख दीजिए डॉक्ट्रिन ऑफ प्रोपोर्शनैलिटी. इट मस्ट बी प्रोपोर्शनेट टू द कॉज. CAUSE. ठीक है? अब नहीं समझ रहे हैं तो क्या? डॉक्ट्रिन ऑफ प्रोपोर्शनैलिटी. It must be proportionate to the cause, doctrine of proportionality. Third point जो सुप्रीम कोर्ट ने कहा, it must have a legitimate state purpose. It must have a legitimate state purpose. इट मस्ट हैव अ लेजिटिमेट, यानी समझ रहे हैं ना, मंत्री जी को मन किया फोन टैप हो जाए, so is it a legitimate state purpose? No, it is not a legitimate state purpose. There was a, what you call, somebody, there was a theft in the locality. Do you think that it is valid reason to get into the phones? Okay, so this is a breach. And in Indian Evidence Act also, private conversation is not admissible as evidence. Okay, hearsay evidence तो Indian Evidence Act में है ही नहीं admissible. दो लोग बात कर रहे हैं, मजा आ गया कल जो चोरी की. Okay, so two people are, the third person is hearing, and he goes to the police station and says, so hearsay evidence is not admissible as an evidence in Indian Evidence Act. बहुत ही strict law है. Evidence admissible होना बहुत tough है. Only some exceptions are there. Dying declaration, section 27. मरते वक्त इंसान, उसका प्रिंसिपल ही यही है कि मरते वक्त इंसान सच बोलता है. डाइंग डिक्लेरेशन में जिसने जो बोला, जिसका भी नाम ले लिया, बट बिट्टू, बबली, पिंकू, राजू, राजेश, सबने बुरा किया मेरा, सब जाएंगे. ओके, क्यों? बिकॉज डाइंग डिक्लेरेशन इज वन ऑफ द एक्सेप्शंस ऑफ इंडियन एविडेंस एक्ट 1872. स्पेशल पढ़ाया जाता है. इट हैज वेरी हाई वेरासिटी बिकॉज इट इज बिलीव दैट मरते वक्त व्यक्ति सच ही बोलता है. ओके, सुन, हाँ हाँ, सोसाइटी के, सुसाइड के केस में डाइंग डिक्लेरेशन अंडर अबेटमेंट टू सुसाइड का केस दर्ज होगा आईपीसी 306 में. ओके, और जिन्होंने अबेटमेंट किया था, दे ऑल, हाँ, नाउ एक्चुअली दैट इज एन एविडेंस, बट नाउ द प्रोसिक्यूशन हैज द ड्यूटी टू, उसमें भी कॉन्ट्ररी, अभी इतने केसेस हैं, अब छोड़िए, हटाइए. Somebody, the best dying declaration case in India is that Nirbhaya case. So she gave a dying declaration before a magistrate when she was in, actually she was a brave lady. मतलब under those circumstances she narrated everything before a lady magistrate who went to collect the, that was a, they were all convicted on the corroborative evidence तो था, लेकिन जो main evidence था on the dying declaration of that lady. Okay, so that brave lady, so that was the dying declaration. That is also an example. ऐसे भी एक केस है, कई केसेस हैं. Okay, so this is something which is, so right to privacy is a right under article 21. है कि नहीं है? अभी भी सोचिएगा. हाँ है, उतने देर से क्या चल रहा था. हाँ हाँ, अभी देखेंगे नया बिल, अभी पास कहाँ हुआ, आज भी मैं देख रहा था. It is it violating right to privacy? Very common question. सच कहें तो मुझे कैसे पता what the Supreme Court will, if I give my opinion, which I can give, but which I'll not give. Okay, so any law that is passed by the parliament is not violating anything. That is what you need to write. You can criticize that better consultation, taking stakeholders in confidence, bill referred to department related standing committee. You can write all these things without actually directly attacking a piece of legislation which has the legitimacy of the parliamentarian. Better consultation, more taking into account stakeholders. The bill can be referred to department related standing committee. Malimat committee recommendations on police reforms can be taken. Nandini Satpathy versus PL Dani case. कुछ कह के अपनी बात को दूसरों के थ्रू, हाँ, you say the same thing through others without you writing, because they will judge कि अभी इसका ये हाल है तो आने के बाद तो, so you are not supposed to directly criticize a piece of law that has been passed by parliament. That is a settled proposition. You may have an opinion, you may very politely put that without actually criticizing a law. ठीक है, that is right to privacy. So right to privacy हो गया, इसके सारे rights हो गए, और वहां से शुरू हुआ था health, education. Okay, so now we have article 22 of the constitution. लिखिए article 22. आर्टिकल 22 देखना जरूरी है. 21 के बाद 22 नहीं आता है, इसीलिए 21A लिख दीजिए, मैं भूल गया था. लिखिए, इजी है, 21A बहुत इजी है. आर्टिकल 21A बहुत ज्यादा इजी है. ओके ओके, नाउ आई विल आस्क अ क्वेश्चन. बचपन से सुना है 86 कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट इन द ईयर 2002 आर्टिकल 21A वाज एडेड. ओके, एंड इट आल्सो एडेड. अब मैं एक क्वेश्चन पूछता हूं, Okay, which of the if I am writing in Mandarin, you just translate. Okay, which of the following articles were amended by 86th Constitutional Amendment Act 2000? ये तो मालूम होगा ना, 86 Constitutional Amendment Act 2002. इसमें भी कोई डाउट है? ठीक है. Which of the following articles were amended by 86वां संविधान संशोधन? Okay, you have A. अब सुनिए, A added और were amended और added, दोनों कर देता हूं, ठीक है. A is Article 40, okay, 46. B is Article 36. C is Article 21A. D is Article, ठीक है. और ऑप्शन दिस इज 1 2 3 4 करते, तभी तो ऑप्शन देंगे. 1 2 3 एंड यूपीएससी इतना आसानी से मार्क्स थोड़ी देता है. नाउ A is 1 and 2. B is B is 1 3 and 4. C is 2 3 and 4 and D is 1 2 3 and 4. Okay, 3 and 4. Okay, so now I am asking which of the following article were added or amended by 86 Constitutional Amendment Act. पहला नंबर पे आर्टिकल 46, दूसरे पे आर्टिकल 36, तीसरे पे 21A और चौथे पे 51A. ऑप्शन है A 1 and 2. ओके, B is 1 3 and 4. ओके ओके, इसको एक सेकेंड, सॉरी, एक छोटी सी 45 और 35 करते, कन्वीनियंट रहेगा, फंडामेंटल राइट. नाउ यू से व्हाट इज द आंसर? हाउ मेनी ऑफ यू से दैट D, विच ऑफ द फॉलोइंग आर्टिकल्स? D है 3 and 4. ऑनलाइन वॉरियर्स प्लीज आंसर. अभी हाउ मेनी ऑफ यू से दैट D for Delhi is the answer? D for Delhi is the answer. I am again repeating the question. Which of the following articles were added or amended by 86 Constitutional Amendment Act? Okay, so article statement 1 में है article 45, 2 में है 35, 3 में है 21A और 4 में है 51A. Okay, A में है 1 and 2, B में है 1 3 and 4, C में है 2 3 and 4 और D में है 3 4. So how many of you say that D for Delhi is the correct answer? बस इतने ही लोग. Okay, any other answer? How many of you say A is the correct answer? How many of you say B is the correct answer? B is the B for Bombay. Okay, how many of you say that C is the correct answer? Okay, why do you say B is the correct answer? Okay, so अगर ये लॉलीपॉप रहता तो मैं तो पूछता नहीं. If it would have been that easy, so I would have never asked this question. मैंने पूछा है यानी मुझे मालूम है. Answer is B for Bombay. Okay, why answer is B for Bombay? That is what I wanted to convey, and UPSC will ask this question only to trap 98%. क्यों? Article 21A was added, that the state shall provide free and compulsory education to the children in the age group 6 to 14. Article 51A में 11th fundamental duty भी जोड़ दिया कि it shall be the duty of parent or guardian to send their children to school. पर आर्टिकल 45 में था the state shall provide free. जैसे मैंने 16 आर्टिकल 16 में लिखवाया था, it was to implement article 103rd constitutional amendment implemented article 46 of the constitution. Did we not write this? Okay, ये आपको नहीं मालूम. So article 45 says that article 45 में लिखा हुआ था the state shall provide early childhood care and education to the children in the age group 0 to 14. 0 to 14. So 0 to 14 में से 0 to 6 वहीं रहने दिया, 6 to 14 आर्टिकल 45 से उठाकर 21A में डाला. Please listen to me carefully. Article 45 में it was written that the state shall provide early childhood care and education to all children in the age group 0 to 14. So 0 to 6 has been kept in Article 45 and 6 to 14 has been lifted from there and inserted inside. क्यों 0 to 6 has been left over there? Huh? By mistake? क्यों? It is impossible to provide fundamental right to 0 to 6 years. Every 1 kilometer you have to establish a child creche. If it will become a fundamental right to take care of a newborn baby of 1 year, then the mother will, while going to office, will put the child in it is a fundamental right in the child creche and go to office. So if it will become fundamental right, it will become justiciable. So practically implementing early childhood care in the age group 0 to 16 as a fundamental right is impossible. You have to open a child creche after every 1 kilometer in the country. कि जो भी पेरेंट्स ऑफिस जा रहे हैं, अर्ली चाइल्डहुड केयर अब किसका जिम्मेदारी है? अब तो स्टेट का हो गया, और वो भी फंडामेंटल राइट. सो बच्चे को वहां रखा, चले गए मूवी देखने. सो गेटिंग माय पॉइंट. सो इट इज लाइक it was impossible to implement 0 to 6 as a fundamental right. So 0 to 6 को अभी भी directive principle में रखा. Government is doing best what it can. Mission Indradhanush, Universal Immunization Scheme, ICDS, Integrated Child Development Scheme, Indira Gandhi Matritva Yojana, now Pradhan Mantri Poshan and all. So women is being, lactating mothers are given, then infant mortality rate, maternal mortality rate, so many things are associated, social health activists, that is Ashas, so many things government is actually doing to implement Article 45, but not making it a fundamental right. Otherwise, you have to open a child creche after every 1 kilometer. So 0 to 6 has been kept in Article 45 and 6 to 14 has been lifted from there and put in Article 21A. So the correct answer is B, that is 1, 3 and 4. Article 45, Article 21A and Article अब आता है. It says that the state shall provide free and compulsory education to the children in the age group 6 to 14. So ये citizens को है कि सबको है? सबको. वहां कहा उन्होंने citizens children? नहीं कहा ना. आर्टिकल 350A में कहा द स्टेट शैल प्रोवाइड प्राइमरी एजुकेशन इन मदर टंग टू द चिल्ड्रन ऑफ लिंग्विस्टिक माइनॉरिटीज. सो वहां कह रहा है ना, सिटीजन कह रहा है, वहां भी नहीं. यहां कह रहा है द ऑल चिल्ड्रन, द स्टेट शैल प्रोवाइड फ्री एंड कंपल्सरी एजुकेशन टू द चिल्ड्रन इन द एज ग्रुप 6 to 14. ये इंपॉर्टेंट नहीं है, कॉमा देके, इन द मैनर एज स्टेट में डिटरमाइन बाय लॉ. व्हाट विल बी द चाइल्ड टीचर प्यूपिल रेशियो? स्कूल में टीचर प्यूपिल रेशियो क्या होगा? व्हाट इज द मीनिंग ऑफ टर्म फ्री? अगर ऐसा होता तो फंडामेंटल राइट होता, तो व्हाई यू आर चार्जिंग 10 रुपीज इन गवर्नमेंट स्कूल? केंद्रीय विद्यालय इज चार्जिंग 100 रुपीज. द स्टेट शैल प्रोवाइड फ्री एंड कंपल्सरी एजुकेशन टू द चिल्ड्रन. यहां तक तो पढ़ लेते हैं. आगे कहता है इन द मैनर एज स्टेट में डिटरमाइन बाय लॉ. सो द स्टेट हैज पास राइट टू एजुकेशन Act 2009. What is the meaning of term free? What is the meaning of term compulsory? What is teacher pupil ratio? What is the definition of neighborhood school? What shall be school management committees? Whether economically weaker section seats would be reserved? Whether physical punishment can be given or not? Who will share the financial resources? National Commission for Protection of Child Rights would be established. What are the other facilities that will be provided? All this thing is written in Right to Education Act 2009. So to implement Article 21A, you need another law to actually, like in Article 17, it says, untouchability is abolished. Practice in any form is forbidden and is punishable by law. तो law बनाना पड़ेगा ना, कि क्या सजा मिलेगी अगर आप what will be the punishment? So you need SC/ST Prevention of Atrocities Act 1989 and Protection of Civil Rights Act 1955. So Article 23 says that child labor is abolished. 24. So you have Child and Adolescent Labor Prohibition and Regulation Act. Article 23 says immoral trafficking should be banned. So Immoral Trafficking Abolition Act and Bonded Labor Abolition Act. So उस provision को implement करने के लिए you need a law. Article 42 says that the state shall provide maternity relief. So Parliament ने Maternity Benefit Act 1961 pass किया. So to implement a constitutional provision, you need a ordinary law. Constitution says separate judiciary from executive. State ने CRPC 1973 बनाया, taking all the powers of the judiciary from state civil servants. It says na Article 50, you'll see that. So many of the provisions of Constitution are implemented by another law, which, and these rights are not called as self-executory rights because they need a law to actually make them happen. So right to education to bas keh raha hai, the state shall provide free and compulsory education to the children in the age group 6 to 14 in the manner state may determine by law. So there is a law, उसमें एक लाइन में बात खत्म हो गई, उसकी हजारों बातें अभी बची हुई हैं जो डील कर रहा है राइट टू एजुकेशन एक्ट 2009, where you have all the provisions, and UPSC will not ask a chavanni question that what is article 21A 6 to 14 और आप खुश हो गए. UPSC will ask what are the major provisions of right to education act 2009, or they will lift from the preamble of right to education act and they will ask you to comment critically, and then you will say 21A में तो बस उतना ही याद था, 6 to 14 अब लिखो तो लिखो क्या इसमें. Like they asked a question that how do you think Indus Valley civilization's urban planning can be implemented in modern times? Means का question है. अब rectangular shape urban planning के आगे कुछ याद ही नहीं है, तो फिर वही ब्रोंज डांसिंग गर्ल लिखा. जो यूपीएससी ने पूछा नहीं था. यूपीएससी ने कहां पूछा हाउ डू यू थिंक इंडस वैली सिविलाइजेशन टाउन प्लानिंग कैन बी इंप्लीमेंटेड इन मॉडर्न टाइम्स. सो वो पूछ रहा है बस अर्बन प्लानिंग. यू स्टार्टेड विथ आलमगीरपुर, दाइमाबाद, getting my Mohenjo-daro, 7 rivers, Indus. You talked about Bonsgal, Lothal, Husk, everything other than, because you know only one line, that rectangular shape, urban planning. So UPSC will not ask you a simple question from 20. They will say what are the major characteristics of Right to Education Act 2009 or critically evaluate the performance of Right to Education Act. इस साल ज्यादा इंपॉर्टेंट है. क्यों? एक व्यक्ति बोलिए. हाँ क्या? न्यू एजुकेशन पॉलिसी को तो 2 साल हो गए. हाँ क्या क्या? कौन सा क्राइसिस? यूक्रेन क्राइसिस. कोई बात नहीं. ही इज थिंकिंग ओके, बिकॉज द मोस्ट इंपॉर्टेंट रिपोर्ट ऑन राइट टू एजुकेशन every year is published by Pratham. Pratham publishes annual status of education report, ASER. That is the Bible of school education in India. In school education ka qualitative and quantitative performance. Pratham has got Indira Gandhi Peace Prize. So they can ask the critical performance of Right to Education Act 2009, and this will be a mains question, and you will write one line. The state shall provide free and compulsory education to the children in the age group 6 to 14 in the manner statement determined by law. After that you will think, बोला तो था कि medical education concurrent list पे, you will write. Then you will think कि education is in concurrent list, वो भी लिख देंगे. पर UPSC is asking something different. So we will write on critical पूरे प्रोविजंस. फ्री का मतलब क्या है, कंपलसरी का मतलब क्या है, टीचर प्यूपिल रेशियो, व्हाट इज द evaluation, Indira Gandhi annual status of education report, all these things, what can be expected in mains, we'll be writing in the next class. Okay, and we'll continue. We have done only 20. We are literally going very slow. Okay, so we'll be doing 21A. 21 में तो वक्त लगता ही, पूरा स्पीडी ट्रायल से लेके. ठीक है, so I take your leave. Have a wonderful evening. Thank you.